Item 6 of hearing is, my lord.
Item 6.
Yes, my lord.
Yeah, what happened?
This is a fixed matter, but my lord, is the counsel for the appellant is having personal difficulties.
Okay.
If the matter we take it up on Monday next week.
Next week, Monday?
Yes, my lord. I've
Okay.
taken the consent of the opposite party also.
Okay. Your name, please?
Lomo Maralte.
Mr. Surinso, the learned counsel, appearing for the appellant, submits that the conducting counsel in the instant case, Mr. Jonathan,
Bilaram Enga.
Mr. So-and-so is indisposed today in the court. Therefore, prays for listing of the matter on next Monday, that is on
22nd.
Monday is 22nd, which is not objected by the counsel appearing for the other side. Let the matter be listed on 22nd. Yes.
Your Lordship, the indulgence in making a mention regarding item number 3 of part 2.
3 of part 2.
Your Lordship, yes.
Yes.
Although it is fixed for today, Lordship, the senior counsel for respondent number 2 has hearing in court number 1. So
Okay.
if this matter may be taken up on 23rd June, Lordship, next Tuesday,
23rd.
June.
Okay. MS so-and-so, the learned counsel, appearing on behalf of Mr. H.
LH Tenshima.
Lalin Yarima, the senior advocate, appearing for respondent number 2, prays for adjournment of the matter and listing of the matter on 23rd of June. You have informed the other side? PP is the other side. Okay. Okay. Let the matter be listed on 23rd.
Obliged.
Madam, may I seek indulgence to mention part 2, item number 14?
Part
It is
1.
part 2,
Part
item
2,
number
14.
14. Yes, my lord. As mutual consent, may this matter be listed out.
You are
in
appearing
this week.
for? You are appearing
Petitioner.
for? Huh?
Petitioner.
Petitioner. MS so-and-so, the learned counsel, appearing for the petitioner, prays for adjournment of the matter. When do you want it to be listed?
Next week,
Adjournment for a week. Let the matter be listed in the next week.
much obliged.
Please, Your Lordship, may I make a mention regarding part 2 of item 15?
15.
Yes, my lord. If the matter may be taken up on next week, Thursday.
You are appearing for the petitioner?
Yes, my lord.
Appellant.
Yes, my lord.
Your name?
Mr.
Mr. So-and-so, the learned counsel, appearing for the appellant, prays for adjournment of the matter for a week. Let the matter be listed in the next week.
Daily list for motion item number 1.
May it please, Your Worship. This is an application under Article 215 of the Constitution, read with Section 12 of the Contempt of Courts Act, Your Worship, for initiation of contempt proceedings against the respondents 1, 4, and 5 for not complying with the directions of this Honorable Court.
Respondent number 1, 4, and 5.
Yes, Your Worship.
What about others?
The others, Your Worship, the direction was against 1, 4, and 5 only.
1, 4, and 5.
Para 19. Your Worship. If I may take Your Worship to para 19 at page 21. Para 19, if I may read, Your Worship.
Yes.
The railways, after having utilized the property of the petitioners for execution of its special railway project, cannot take plea relegating the petitioners to the civil court, where they may be subjected to protracted litigation, whereas their counterpart, whose lands were also acquired by the railways for the same project, have already been paid compensation. Since the petitioners' lands have been found to be utilized in connection with the special railway project, namely Bairabi Sairang New BG Railway Line Project, and since it has also come to light that they have not been paid any compensation to which they are entitled, respondents 1, 4, and 5 are hereby directed to initiate process of formal acquisition of land of the petitioners covered under House Pass number 335 of 2015, 336 of 2015, and 338 of 2015 located at Sairang, and thereafter pay due compensation to the petitioners for acquisition of their lands in terms of provisions contained in Railways Act 2019. Are hereby directed to initiate the process of formal acquisition. This was the direction, Your Worship. But in spite of this, if I may take Your Worship to page 24,
Yes.
The respondent number 4 has passed this award. If I may read this, Your Honor.
Yes.
This is from the respondent number 4 to the respondent number 5. Submission of draft additional award to award 3 of 2019. Pursuant to the Honorable Gauhati High Court Aizawl Bench order dated 6/2/2026 and Land and Revenue Settlement Department letter number so and so dated 2/3/26, in connection with WPC 118 of 2024, an assessment is prepared for payment of compensation for 3 house passes located at Sairang, namely House Pass 335 of 2026, 336 of 2026, and 338 of 2026. These plots of land fall within the right of way for construction of the new railway line, but were not included in either of the earlier awards, and no payment was made. Accordingly, an additional award has been prepared in this regard. In this connection, I am forwarding herewith draft additional award to award number 3 of 2019 amounting to 72,34,000 for acquisition of land for construction of new railway line. So, Your Worship, this is the respondent number 4 has made an additional award to the earlier award. But in para 19 of the judgment, Your Worship, there's a clear direction that the process of formal acquisition has to be initiated again under the Railways Act of 2019, 1989.
Okay, we'll issue notice at this stage.
Yes, Your Honor.
Heard Mr. A.R. Malhotra, the learned counsel, appearing for the petitioner. This is an application under Article 215 of Constitution of India, read with Section 12 of Contempt of Courts Act 1971, filed by the petitioner alleging willful and deliberate violation of this court's judgment and order dated 6/2/2026, passed in WPC number 118/2024. Let notice be issued returnable in 3 weeks to the respondents by speed post. Steps for notice shall be taken by the counsel appearing for the petitioner within a period of 3 days from today. Within a period of week from today. Let the matter be listed after 4 weeks.
Item number 2.
Again, Your Worship, this is another contempt petition.
Yes.
If I may take Your Lordship to page 17, para 16 of the judgment.
Yes.
This is the operative portion.
Yes.
Accordingly, the present writ petition is disposed by setting aside the order dated 2nd of December 2021 and communication dated 2nd of June 2022 impugned in the writ petition. Insofar as they deny the claim of the petitioner to count the services rendered by her in officiating capacity in the post of lecturer in pharmacy, now designated as assistant professor in pharmacy in the Regional Institute of Pharmacy and Nursing Science, Aizawl. Respondent number 3 shall now consider the case of the petitioner for grant of benefits under the Modified Assured Career Progression Scheme as applicable to the employees of the institute in accordance with law. If required, by convening a review DPC for the purpose, by taking into account the service rendered by the petitioner in officiating capacity in the post of lecturer in pharmacy, and in case the petitioner is found eligible for grant of benefits, the same shall be released to her expeditiously. The entire exercise shall be completed within a period of 3 months.
Yes.
So, Your Worship, certified copy was also furnished. Page 19 is the letter by which,
Yes.
and till date, Your Worship, no steps have been taken for convening the review DPC.
Okay. Okay. Heard Mr. A.R. Malhotra, the learned counsel, appearing for the petitioner. This is an application under Article 215 of the Constitution of India, read with Section 12 of the Contempt of Courts Act 1971, filed by the petitioner alleging willful and deliberate violation of this court's judgment and order dated 23/9/2025, passed in WPC number 96 of 2024. Let notice be issued to the respondents, returnable in 4 weeks. Notice to be issued by speed post, and the steps for notice shall be taken by the counsel appearing for the petitioner within a week from today. Let the matter be listed after 4 weeks.
I'm over.
For admission, item number 3.
Lordship, for the petitioner, the respondent number 2, my lord, the chief engineer has been transferred out from his post. A new incumbent has been transferred.
So have you filed any IA for this?
For that, I have to take necessary steps. I have to issue notice for that.
Okay.
I'll take necessary steps. my
Okay,
lord.
heard Ms. MS.
Bilal Ramnemi.
So and so, the learned counsel appearing for the petitioner, also heard Mr.
Lian Ming Tanga, on behalf of my senior CGC, Ms. Zairem
You
Sangpui,
are appearing for which respondents?
Respondent 1, Your Lordship.
Respondent number 1.
Yes, Your Lordship.
Okay, respondent number 1. MS so and so, the learned counsel. Yes? Anything?
Your Lordship, for
You-
respondent number 1, through CGC,
Correct. You are appearing on behalf of the CGC, right?
yes, my senior,
Yes.
Your Lordship.
We take his name and like put CGC's name also. Then write learned counsel appearing for the petitioner submits that which respondent?
Number 2.
Respondent number 2. Respondent number 2, namely Sri Girish Prasad Singh, has been transferred from his post of the chief engineer and a new incumbent has joined in place of the respondent number in place of Mr. Girish Prasad Singh. In view of the aforesaid. Okay, how much time you will take to file your affidavit?
My lord, a week's time.
A week's time? Okay. Heard MS so
Miss
your name, please?
Rosie.
Rosie so and so, the learned counsel appearing for the petitioner. Also heard MS
Emily L. Changte.
for respondent for the sole respondent. MS so and so submits that she has the instructions to appear in the instant case and shall be filing the wakalatnama during the course of the day. She prays for further 2 weeks' time to complete her instructions to file an affidavit in opposition in the instant case. Also, the prayer is allowed. Let the matter be listed after 2 weeks.
Obliged, my lord.
Item number 5.
Yes, Your Lordship, I'm representing the state respondent, that is respondent number 1 to 8. And Your Lordship, I'm seeking another 2 weeks' time to file my affidavit.
Okay. You are government advocate?
For the state respondent.
You are government advocate.
Yes.
Your name, please?
Vane Syami.
Vanishyami, okay. Heard Mr.
Signing from a silo.
So in Silo, the learned counsel appearing for the petitioner also heard MS Vanishyami, the learned government advocate for the state respondents. You are appearing for all the respondents, right?
Yes, Your Lordship.
For the state respondents. MS Vanishyami prays for 2 weeks' time to complete her instructions and file an affidavit in opposition in the instant case. Prayer is allowed. Let the matter be listed after 2 weeks.
Deeply obliged.
Item number 6.
Yes.
Your Lordship, this is an appeal filed against the impugned order dated 10/6/2000
Appeal.
against the probate case, probate of will, which was granted in favor of the respondent.
This is RFA. Okay. Service is complete?
Yes, Your Lordship. Service has not been complete. Condonation was allowed in the previous court date. Condonation application was allowed in the previous court date.
A condonation application was allowed?
Yes, Your Lordship.
Okay. You are appearing?
Yes.
You are
Yes, my
appearing
lord. I'm
for-
appearing for the respondent, sole respondent.
You are appearing for the respondent?
Yes, my lord.
The sole respondent?
Yes, my lord.
Sole respondent. Yes.
Yes, Your Lordship, if I may, the facts of the case is that the respondents,
Will admit this matter?
My lord, I just have one point why this appeal should not be admitted.
Why?
Because in the trial court, they were not a party. They were not a party. The appellant are a stranger. And I have relied on one authority. If your lordship permits, I may.
Your Lordship, that is the exact reason why we have appealed.
No, why, okay, let us go to the impugned order.
Yes, Your Lordship. The impugned order is at page 40, Your Lordship.
Page
40.
40. Yes,
Yes, Your Lordship, if I may read.
yes.
From order, paragraph number 1. The fact of the case leading up to the application is that the testator H. Lal Khomaya, during his lifetime, executed a will in the presence of 3 witnesses, namely so and so. The testator H. Lal Khomaya died on 8/6/2024. The contents of the will reproduced below for reference. I will skip that. Moving to para number 3, Your Lordship. In a probate proceeding, the duty of the court is to give seal of the court that the will is genuine and that the will is executed in conformity with the provisions of the Mizo Marriage, Divorce and Inheritance of Property Act. Upon receipt of the petition, the petitioner is directed to bring forth the attesting witness of the said will accordingly. The attesting witness, namely C. Lalbiakvela R. Pakunga and T. L. Sherpa, have submitted their evidence by way of examination in chief, and they have also personally appeared before the court. Should I continue, Your Lordship?
Yes, in there.
In their examination in chief, the attesting witnesses stated that the testator had made the will voluntarily and had signed it in their presence, and accordingly, PW number 1, 2, and 3 also gave signatures on the will. At the same time of making the will, the testator was in good health and of sound mind, thereby fully possessed of a clear conscience and capable of exercising his own free will. The petitioner also produced the original will executed by the testator, H. Lal Khomaya. Now it is to be considered whether the will is valid as per section 29 of the Mizo Marriage, Divorce and Inheritance of Property Act 2014. There is no material proposition of fact or law denied by any person in the present case due to which question of framing of issue mandatorily arises for adjudicating of the case. Further, in view of subsection 2 of section 29 of the said act, it is evident the probate application has been filed within the limitation period as the testator died on 8/6/2024. The petitioners, witness number 1, 2, and 3 deposed that they were at the time the testator had made the will dated so and so. I have perused the will and I am satisfied that it is genuine and that the attesting witnesses had put their signatures as required by law, and there is no reason to discredit their evidence. From the evidence on record, it is clear that the will was made voluntarily and that the testator was in sound mind at the time of writing of the will. Furthermore, as the wife of the deceased testator has testified to her consent for probate of the will, I am satisfied that the will executed by the testator H. Lal Khomaya is the last and the final will, as there is nothing on record or elsewhere to suggest otherwise. Therefore, from the averments in the application, evidence and documents placed on record, this court is satisfied that the conditions for execution of the will as required under section 29(7) of the Mizo Marriage, Divorce and Inheritance of Property Act has been fulfilled. Further, there is no legal impediments as per law not to probate the will in favor of the petitioner. Accordingly, it is held that the petitioner, Srimati Larinkimi, is entitled for probate of the will executed by the deceased husband, H. Lal Khomaya. The will executed by the deceased H. Lal Khomaya, so and so, is hereby probated in favor of the petitioner, namely Srimati Larinkimi, in accordance with law.
Yes, and who are you?
I am there are 3 appellants. These are the children of the deceased H. Lal Khomaya. And we are the children of the deceased H. Lal Khomaya. And the respondent herein is the second wife of the deceased. So
This Lalkarnimi is the second wife.
Larinkimi is the second wife of the...
She is the second
Yes,
wife.
I am the second wife.
You are the second wife.
Yes, ma'am.
So, Your Lordship, the main reason for appeal is that we were not given an opportunity of being heard in regard to the instant probate case. Initially, Your Lordship, the respondent had filed an heirship certificate application. Initially, the respondent herein had filed an heirship certificate application.
What certificate?
Heirship certificate.
Okay.
Application in respect of the same property. The application was allowed but was challenged in review, and the heirship certificate was set aside. And after setting aside of the heirship certificate, the respondent again approached the court for issuance for probate of the will, which was not placed on record at the time of filing of the heirship certificate. So in that regard, there are certain allegations made by the appellants herein that regarding the genuinity of the will, as well as the fact
No
that
notice was given in the probate
no
case. to you?
notice was given, Your Lordship.
Yes, what do you
Yes.
have to say?
My lord, when I have filed this probate application, the trial court has rightfully come to a finding that this will was genuine. The will that is executed by my late husband was genuine. So the trial court has probated the will, and then the trial court has also given me liberty.
In a probate proceeding,
Yes.
and what are the requirements in a probate application? Because the will is there, but he has the children also.
Yes, however, I'm the second wife. I have no children with him. The appellant are the children of
First wife.
Yes, first wife with his first wife.
Correct.
So now, according to
What
the
is
will,
the law? What is the law of inheritance? Otherwise, under the Mizo customs, as per the Mizo, what is this law? What is
So
this?
marriage, divorce, and inheritance.
Huh?
Mizo marriage
Mizo marriage.
of Inheritance of Property Act.
Yes.
Yes,
What is the provision?
according to this, under section 29,
Under section 29.
yes, my lord.
Section 29. Yes.
Yes. Under this provision, my lord, there is no specific provision that says that notice should be issued. It merely says that the probate of will must be made within 5 years from the death
The
of the
29 is will, right?
Yes, yes, my lord.
What is there? What is written there? Let's see. A person of sound mind who was attained majority while he is fully possessed by clear conscience may execute a will in writing in presence of at least 2 witnesses. So and so and so. If the testator executes more than one will, okay, making a will. First wife died, or like there was a
Yes,
divorce?
first wife died.
First wife died.
Yes, Your Lordship. And it is the appellants who are residing in the disputed property till date. The deceased and the present wife, they have moved out from the property which is in contest in the instant case.
This case has to be looked into. We'll admit this
Yes,
matter.
yes, my lord.
We'll admit this matter. Heard
And
Mr.
if TCR may be called, my lord.
PCR will be required.
Yeah, yes, if we have not annexed the evidence of the
You have not. Okay. Heard Mr. So and so, the
Jonathan
learned
Lorenzo.
counsel, learned counsel appearing for the appellant. Also heard MS so and so, the learned counsel appearing on behalf of the sole respondent. This is an appeal under section 17 of Mizoram Civil Courts Act, 2005, read with sections 96 and 151 CPC 1908 against the impugned order dated 10/6/2025 passed by the Civil Judge Senior Division in probate application number 1 of 2025. The learned counsel for the appellant submits that in the probate proceeding, the probate proceeding before the Civil Judge Senior Division, the petitioners have not been made any party, and therefore there was no opportunity given to the petitioners for placing its case before the probate before the Civil Judge Senior Division in the probate proceeding. Full stop. After hearing the parties, after hearing the counsel appearing for the respective parties, this court is of the considered opinion that the matter should be admitted at this stage. Full stop. Accordingly, admit the appeal all for the TCR in connection with probate case number
1 of 2025.
1
of 2025.
of 2025 from
sir.
the Court of the Civil Judge Senior Division,
Sampai.
Champai. Let the matter be listed after 3 weeks.
Yes. And my lord, I am yet to receive the copy of the petition.
Yes, we can serve a copy.
A copy of the appeal. The learned counsel appearing for the appellant shall serve a copy of the instant appeal to the counsel appearing for the respondent during the course of the day.
Yes, Your Lordship.
During the course of the day. So let the matter be listed after 4 weeks.
Obliged, Lordship.
Item number 7.
May it please your lordship. This is an appeal against the impugned judgment order dated 12/3/2026, along with the decree dated 12/3/2026 passed by the Court of Civil Judge Senior Division 6, Aizol, in civil suit number 23 of 2019. The appeal is due to the fact that the trial court.
We'll issue notice at this stage.
Yes, my lord.
At this stage, we'll issue notice only. Okay. Heard, Mr.
Zoram Chana.
Joram Chana, the learned counsel appearing for the appellant. Is there any other application along with this?
Yes, my lord. I've filed one IA for stay.
IA will be considered later on.
Yes, yes.
Heard Mr. Soyens, the learned counsel appearing for the appellant. This is an appeal under section 96 CPC, read with order 41 CPC, read with section 17(2) of the Mizoram Civil Codes Act against the impugned judgment and order dated 12/3/2026, along with the decree dated 12/3/2026 passed by the court, learned court of the Civil Judge Senior Division number 6, Aizol, Judicial District, Aizol. Let notice be issued to respondent numbers 1 and 2 by speed post. Steps for notice to be taken within a period of week from passing of this order by the learned counsel appearing for the appellant. Let the matter be listed after 3 weeks.
Yes, my lord.
After 3 weeks or 4 weeks? After 4 weeks.
3 weeks, my lord.
After 4 weeks.
And my lord, in the IA, interim stay may be granted because the trial
The
court.
IA will be considered once notice is served.
My lord, if your lordship permits interim stay because interest has been charged upon the present appellant. Interest.
What?
Interest. The trial court had directed the appellant to repay rupees 18 lakhs with interest at the rate of 5%. So interest will, if the interim stay is not granted, my lord, the interest will go on. So at this stage, interim stay may be granted, my lord.
No, I mean, only 3 weeks. 3 weeks time. We are not going to stay. Let the notice go. let the notice go and like on the next date it will be considered.
Yes, in the IA also, my lord, let notice go, my lord.
The I also in the I also write this and this is an application under section 41 rule 5 read with section 151 of CPC for stay of judgment and order dated 12/3/2026 along with decree dated 12/3/2026 passed by the court of the civil judge in bracket senior division in bracket stroke 6 Aizawl district Aizawl in civil suit number 23 of 2019. Let notice be issued to the respondents by speed post, returnable in 4 weeks, returnable in 3 weeks, returnable in 3 weeks. Steps for notice will be taken by the learned counsel for the appellant by within a period of within a week of passing of this order. The prayer in the IA shall be considered on the returnable date.
Yes, obliged, my lord.
Item number 8.
Lordship, as per the office note, the trial court reports has come. So trial court reports has come. So if in this matter, Lordship, paper book will be needed. So paper book.
Paper book will be required.
Yes.
Or TCR has come.
Yes.
Okay,
So if a direction can be made.
Okay, heard MS so the learned counsel appearing for the appellant. Also heard Mr.
Raymond.
Your name?
Raymond Odessa.
So for the sole respondent.
respondent, yes.
For the sole respondent. TCR in the instant case has already been received. As per the note, the office note dated 11/6/2026, registry to prepare the paper book, and after preparation of the paper book, let the matter be listed for admission.
Item number 9.
Yes, may it please your lordship.
So paperwork has to be prepared.
Yes, my lord. At the cost of the appellant.
Okay, heard MS so the learned counsel appearing for the appellant. Also heard MS so the learned APP.
Yes, Your Lordship.
Learned APP for the state of Mizoram. TCR in the instant case has already been received as per the office note dated 29/5/2026. The registry to prepare the paper book, and after preparation of the paper book, let the matter be listed for admission.
Obliged.
Item number 10.
Lordship, the office notes indicates that ID card has returned from respondent number 1 and 2. But however, none has appeared today. So if this...
So we'll post it for another date.
Yes, Your Lordship.
Heard MS so the learned counsel appearing for the... You are appearing for the applicant.
For the petitioner, it's a criminal, it's a civil revision petition.
Okay, for the petitioner. As per office note dated 16/6/2026. Duly signed AD cards from both the respondents have been received by the registry. However, none has appeared for respondent numbers 1 and 2. For interest of justice, let the matter be listed after 2 weeks.
Item number 11.
Your Lordship, this is a bail application under 483 BNSS. Right? Bail application.
Bail.
Yes.
Yes, what happened?
Your Lordship, the accused was arrested by Site 12 police personnel
One
on
second.
7/1/2026. Your Lordship, this is
This
the
has
first
come
time.
for the first time.
Yes, my lord. If notice may be issued.
Okay, we'll issue notice. Is anybody appearing for the state of Mizoram?
Your Lordship, will be
NDPS, somebody else is there? Who is appearing? Okay, Mary is
I
appearing.
am Your Lordship.
Okay.
Yes, Your Lordship.
Heard Mr. So-and-so, the learned counsel appearing for the accused applicant. Also heard Ms. Mary Kainte, the learned APP. You are APP?
Yes, Your Lordship.
Learned APP. Learned additional PP for the state of Mizoram. This is an application. This is an application under section 483 of BNSS, read with section 37 of NDPS Act, praying for release of the accused applicant in connection with NDPS case number 83/2026, registered under section 18 small v of NDPS Act 1985. Call for the CD, let the matter be listed after 2 weeks.
Your Lordship, if the matter may be listed next Tuesday,
Your
23rd.
Lordship, CD is in as much as charge sheet has already been submitted.
Charge sheet
and they-
already been submitted?
Yes,
Yes,
and
my
they
lord, we annex the charge sheet.
Okay, then TCR has to be called for. Then the registry to call for the TCR in connection with NDPS case number 83/2026. From which court?
from the special judge, ISOL, NTNPS.
Special NDPS court, Aizawl. Special court in bracket NDPS, Aizawl. Let the matter be listed. When it can be reached, Mary? Madam Mary?
Your Lordship, if it can be listed on Thursday, and Your Lordship, one more submission. Usually a scanned copy of the TCR is called
Scan
for
copy
in
of the
this-
TCR, right? Scan copy of the TCR, right? Scan copy of the TCR, and let the matter be listed on next Thursday. That is on 25th. Let the matter be listed on 25th. Or
Sorry, Your Lordship, I have some commitment.
So,
I have commitment on Tuesday.
let the matter be listed on 24th of June.
Let's
24th of June.
Thank you very much.
For hearing item number 12.
Yes.
Lordship. This is a criminal appeal, Lordship, and this criminal appeal is against the impugned judgment and sentence dated 18/10/2024, passed by the learned special judge in the NPS Champai. In criminal trial number 197 of 2023, and there are two accused in this particular case, Lordship, and I, along with the co-accused, were.
State you are ready?
And I, along with the another co-accused, were convicted.
One second,
to,
one second, one
Lordship, yes.
Yes.
Also, this is criminal appeal against the impugned judgment and sentence. Dated 18/10/2024, passed by the learned special judge and the NPS Champai. There are two accused in this particular case, Lordship, and I, along with the another co-accused, were convicted under section 21C and 25 of the NDPS Act.
21C and
25 of the NDPS Act to undergo for a period of 10 years. Sentence was for rigorous imprisonment for a period of 10 years and to pay a fine of rupees 1 lakh. And in default of payment, the appellant, along with the co-accused, shall undergo another simple imprisonment for 6 months, Your Lordship.
Yes.
And the brief facts of the case is that on 26/4/2023, an FIR was submitted by one of the police personnel stating that he had received a telephonic information wherein it was stated that a huge amount of suspected contraband items were transporting by one vehicle, and the said vehicle was detained along with the occupants. And on arrival of the police personnel, 80 soap cases of the suspected heroin were recovered from the said vehicle. The vehicle is I-20, bearing registration number MZ01E7744, which was driven by the co-accused, Your Lordship. And the suspected heroin was weighing 894.18 grams. 894.18 grams. So, and a case was registered under Section 21C and 25 of the NDNPS Act against the present appellant and the co-accused. And there are as many as 5 witnesses from the prosecution side and only 1 witness from the defense side. And after taking all the evidence, I, along with another co-accused, were convicted, for which I've already narrated, Your Lordship. And at the outset, Your Lordship, the other co-accused also filed an appeal before this honorable court, which was allowed.
Appeal is allowed?
Appeal is allowed, Your Lordship. And appeal is allowed, and he's already released. He's already acquitted, Your Lordship. And
why this matter was not taken up together with this?
Lordship, because we are different counsels. So they have already filed a bit earlier.
Huh?
They have, the co-accused had filed the appeal a bit earlier than me. So I have
But
filed...
but both the matters could have been heard together.
Heard together, Lordship. However, it was not clubbed together. So it was listed
Your
separately,
Lordship,
Lordship.
if I may, in that regard, Your Lordship, the circumstances and the evidence against both the accused are different. So the parity cannot be.
I'll come to that, Your Lordship. I may be allowed to submit the order passed by the coordinate bench.
Yes.
This is a criminal appeal number 7 of 2025. Name of the appellant petitioner was Joseph Lalding Heta, who was the co-accused, Lordship. And may take Lordship to the operative part, which is at page 16, paragraph number 23, starting from paragraph number 23. Since I'm going to rely on the same grounds, Lordship. May I read, Lordship?
Yes.
It has to be remembered that the provisions of the NDNPS Act are both stringent and rigorous, and therefore the burden heavily lies on the prosecution. At the outset, the prosecution has to prove the fundamental facts of the case. The fundamental facts in NDNPS case are the essential, primarily facts that the prosecution must prove beyond reasonable doubt before the court can invoke legal presumption of guilt against the accused. Particularly under Section 35 and 54, Section 35 is presumption of culpable mental state, and 54 is presumption from possession of illicit drugs, Lordship. 35 and 54 of the Act, these facts constitute the roots of the case and must be established to satisfy the stringent requirement of the Act. The key fundamental facts are: number 1, valid search and seizure; number 2, conscious possession; number 3, proof of contraband; number 4, chain of custody and sampling; and number 5, documentation, full report of the arrest and seizure to superior officers within 48 hours. If these fundamental facts are not proved, the statutory presumption against the accused does not apply and the prosecution case becomes weak. Without proving these fundamental facts, the court has to come to a conclusion that prosecution has failed to prove its case beyond reasonable doubt. In the case of such and such, the apex court held that because the NDNPS Act prescribes extremely harsh punishments and reverses the burden of proof, the prosecution must first prove fundamental facts beyond reasonable doubt before the presumption against the accused can arise. The Apex Court also stated that physical evidence regarding recovered contraband being property of the court in the absence of an order under Section 52A, non-production thereof would warrant drawing of adverse inference under Section 114G of the Evidence Act. For a search and seizure to be valid under the NDNPS Act, the search must be conducted by the empowered gazetted officer or a subordinate authorized by him. The seizing officer must record any information regarding the offense in writing before proceeding the search. A copy of the information recorded must be sent to the immediate superior officer within 72 hours. A detailed seizure memo must be prepared listing the seized items and signatures of the witnesses. The seized articles must be sent to the nearest police station for storage in the police station Malkhana. A detailed inventory and sampling must be done before a magistrate to be considered valid evidence. Moreover, a chain of custody for the seized article is to be proved by establishing an unbroken documented record of possession from the moment of seizure to production in court. This requires detailed testimony and documentation which covers the sealing, transportation, secure storage, and forensic testing, ensuring that the article remains untempered. This would mean that the seized substances must be immediately marked for identification and sealed by the seizing officer with the accused signature. Every transfer of the seized articles must be lodged, including the name of the person handing over the item, the person receiving it, and the date, time, and the purpose of the transfer. The seized articles must be stored in a police station Malkhana, which should be a secure, authorized facility with limited access to authorized personnel in order to prevent tampering. The samples must be transmitted to the FSL and the prosecution has to prove by exhibiting the facsimile of the seal to prove that the sealed sample received by the FSL is the same one which was dispatched after travel before the magistrate. All the witnesses who handled the evidence from the seizing officer to the expert should be able to testify that the integrity of a seal was maintained. Any gap in the chain of custody, such as unexplained delays in sending samples for testing or missing documentation, can raise doubts about the integrity of the seized article. Failure to prove the chain in the custody beyond reasonable doubt can lead to the evidence being unreliable. In the instant case, it is seen that the seizure from the appellant has not been proved beyond reasonable doubt, in as much as the seizure witness PW number 2 and PW number 3 have deposed that they did not see the accused person driving the vehicle or possessing the vehicle or carrying the seized articles. The IO himself stated that the seized articles were not present inside the vehicle when the vehicle crossed the check gate, and he did not actually see who put the seized article in the back of the car. They also could not say how many soap cases were recovered. PW number 4 is the only witness who was actually present at the Tuisen Pai check gate when the appellant was allegedly detained. However, he has not been able to prove that the seized articles recovered from the I-20 vehicle of the appellant was kept by the appellant. He only stated that 80 soap cases were recovered from the back air of the I-20, and the co-accused is I myself, Lordship, had just placed. He stated that it was the co-accused who was carrying the contraband articles in a plastic sack, but he could not see whether the sack contained heroin. The sack was not transparent. PW number 4 is not at all clear whether the seized articles were recovered from the co-accused, who is the present appellant, who was carrying it in a plastic sack, or whether the co-accused kept the plastic sack in the I-20 vehicle. Then it was recovered from the vehicle. The rest of the PWs, including the independent witnesses, have all traveled to the PO from the police station at Kozol. In fact, the evidence is very vague as to the exact spot from where the recovery was made. As far as compliance of 52A and DNPS Act is concerned, the same is vital in the instant case, as the seized articles were never produced physically before the trial court, Lordship. Even if, assuming it was destroyed, the prosecution could not show on what authority it was done. It is very relevant, Lordship. It is seen that the prosecution could only produce and exhibit the inventory and photographs. The prosecution could not produce the list of sample drawn from the seized contraband duly certified by the magistrate. In the case of Binod Yadav Supra, the division bench had specifically held that an obligation was cast on the prosecution to produce and exhibit inventory, photographs, and list of sample drones from the seized contraband certified by the magistrate regarding the correctness of the list of samples so drawn, as this would be the primary evidence to bring home the charge against the accused. In fact, the division bench held that when this primary evidence is not available, the trial will be vitiated. Also, there is no primary evidence in this case. 26. It is also pertinent that a perusal of the order sheet of the trial court shows that the seized articles were produced before the magistrate on 26/4/2023. The inventory was certified, the photographs were taken, and the samples were drawn from each packet out of 80 packets marked as Exhibit 1 to 80. The order sheet shows that samples were drawn from all 80 packets. However, the FSL report dated 8/6/2023 reveals that only 8 samples were received. The IO in his deposition also stated that only 8 samples were sent to the FSL. Nothing can be elicited that from the evidence about bunching, and as there is no list of samples certified by the magistrate, is not known as to how many samples were actually sent to the FSL. This is a fatal discrepancy and a total violation of the sampling procedure as laid down in the standing notification. The difference in the weight of the samples sent and received by the FSL is also another factor about which the prosecution during the trial was totally silent. Another factor which is vital for the prosecution is that Malkhana register was never produced before the court. Only go-down receipt was produced and exhibited. There is no explanation as to how the seized articles got transferred from police station Malkhana to the go-down, and the chain of custody in between these two places has not been proved by the prosecution, nor has any person being examined to prove that the seized articles remain intact during the transfer. In normal circumstances, the appellant cannot urge any new grounds not set forth in the memorandum of appeal without leave of the court. However, when new grounds are purely legal grounds and do not require any new factual foundation, the court would view the same as a pure question of law arising from the facts already on record. The appellant was argued on grounds which are not in the memo of the appeal. However, the same are based on purely legal grounds, and there is no bar for the appellant to raise such grounds. As the consequence of the above discussion, this court is of the opinion that the failure on the part of the seizing officer to send the full report of arrest and seizure to his superior officer within 48 hours, the gaps in the chain of custody with regards to the seized article, the inability of the independent witnesses and the IO to prove the recovery from the accused person, the non-production of the certified list samples drawn from the seized item, the non-production of seal facsimile, and the non-production of Malkhana registered, all goes to show that the prosecution has been unable to prove the foundational facts of the case beyond reasonable doubt. And reluctantly, the accused appellant is entitled to the benefit of doubt and as such the impugned judgment and order dated such and such passed by the learned special court and DNPS convicting of the appellant is set aside. Lordship, is set aside and the appellant is acquitted of the charges.
Yes.
Lordship, this is the grounds of setting aside of the this judgment and order dated 18/10/2024. Lordship, I am relying on the same grounds because the facts remains the same. Because all the lacuna and all the missing on the part of the prosecution, all the negligence on the part of the prosecutions remains the same, Lordship. So, and apart from that, my grounds are, Lordship, I have, there is a clear violation of section 52A.
Let us see how the seizure was made.
Lordship, yes. Seizure is page 30, this report of the seizure.
Page 30.
30, Lordship. Thirty 31. 30 is the report of the seizure. May I read, Lordship? As per provision of section 57 of NDNPS Act, I am submitting herewith the report regarding the seizure and arrest as under on 26/4/2023. I had seized 80 numbers of soap cases containing brown powder suspected to be heroin weighing 894.18 grams at Tuisen Pai Check Gate Kozol from the joint possession of Lalrosanga and Lalrosanga, who is the present appellant, and Joseph, who is the co-accused, submitted for your kind information. So that was seizure report. And page 31 is the property search and seizure. Lordship, at page 31, serial number 8.
It was seized on 26/4/2023, 2:30 a.m.
2:30 a.m. Lordship.
Person from whom seized, the number one is you, right?
Yes, Lordship.
And the other one is the co-accused, who has
Co-accused.
been acquitted.
Lordship, yes.
And witnesses, two
Witnesses are also similar, Lordship. Similar in the two cases, in the two persons.
action taken, recommended, keeping valuable.
Yes, yes, Lordship. And page 31 is the property search and seizure form. And at serial number 8, Lordship, I would like to draw your kind attention, Lordship. Serial number 8 is action taken recommended for keeping of valuable property kept at police station Malkhana, number NPS, Malkhana registration number is 17/23. So as per this property search and seizure form, the seized article were kept at the police station Malkhana. However, Lordship, the Malkhana register was not produced before the trial court, and it was not exhibited at all. And what they have produced is a go-down receipt, which is one of my points, Lordship, which is at page 41. May I take Lordship to page 41? So this is the go-down receipt. Received 80 soap cases, packages, containers said to contain heroin number 4. Lordship, got it?
41.
Page 41. Yes, 41. So, Lordship, here it says that it was kept at the go-down.
So what is the difference between a go-down and a Malkhana?
Lordship, Malkhana, there is a notification. In the Malkhana, there should be some form which we have to keep, and there's form 1, 2, and 3, Lordship. That has to be complied with. So what very clear is that they have not done on their part. So they are trying to hide something. So instead of that, they have put the go-down receipt. This is my submission, Lordship. And here it seems that there are 2 records, and one record says that SA were kept at the Malkhana police station, which is at page 31, which I have read out, Lordship. Malkhana registration number 17 of 2023, which was kept on 26/4/2023. and another record, which is a go down receipt, which shows that it was kept at the go down. So the prosecution, how the prosecution kept the SA in two different places at the same time. So there is no explanation at all. No explanation at all, Your Lordship. So it cannot be kept the same, this article in the two different places, since there is no explanation at all. And that has been considered by the coordinate bench of this honorable court, Your Lordship, which I have read out.
So basically your grounds are same,
Same,
because
Lordship.
at
Yes,
the
yes.
same time you have been arrested. Only thing is difference is that there was a witness which said that you have kept that black sack or whatever
Very true, Lordship.
behind the back of the car.
Very true, Lordship. Yes, yes.
But the co-accused was basically released on the ground of not following the proper procedure.
Very true, Your Lordship. On technical ground.
While
Yes, there-
seizing, sampling, and sending it, making
Yes, yes,
inventory
very
and all
true.
these things. The
Yes.
procedural aspects
Very true,
left in
Lordship.
the procedural aspects.
Yes, yes, yes.
basically. So your grounds are basically same.
Basically same. And apart from the grounds which I've relied upon, Lordship, I have some few points which there are so many discrepancies in the prosecution evidences, Lordship. So the seizing officer, the seizing officer who is the person who filed the FIR, which is at page, Lordship, is the person at page 7.
FIR is it page?
FIR is in the beginning, but at page 1, Your Lordship.
Page 1 only.
Page 1 only. And the person who submit the FIR is the seizing officer, Lordship. And the seizing officer here clearly stated that the seized article were, weighment of the seized article were done at the spot, Lordship. Here it clearly says that. However, another police personnel had stated that who is a PW number.
And this
four-
weight was done with the soap cases, without soap cases.
That is also not revealed, Your Lordship. So that is one of my grounds. And the PW number 4, who is the police personnel who accused me to carry the contraband items, he said that weightment was not done on the spot. So 2 police personnel were called, and both of them are contradictory to each other, Lordship. So even from the prosecution side, not only from the independent witnesses, from the police personnel, they are contradictory to each other. And besides that, Your Lordship, the number of recovered heroin, which is at page 11, Your Lordship, may take Lordship to page 11, who is the independent witness. He deposed that the independent witness had deposed that the police personnel had recovered and seized 80 soap cases, Your Lordship, which is at page 11 in his deposition, Your Lordship. Page 11, and this person. The 4th line, Your Lordship.
Page 11 is deposition of.
Deposition of the independent witness. In the 4th line, Your Lordship, seizing party recovered and seized 80 soap cases. Lordship got it?
Yes.
And this is his deposition. But in his cross-examination, which is at page 12, second last paragraph, it is a fact that I did not know the weightment of the seized article contained in each soap cases, and the number of soap cases is 20. In his deposition, he said that it's 80 soap cases. In his cross-examination, he had changed from 80 to 20. So it is not known which one is correct. And he said that the weightment is also done in his presence. He had clearly stated in his deposition. However, in his cross-examination, he said he did not know the weightment of the seized article. And besides, Your Lordship, the PW number 3, the same person, the same this independent witnesses had stated that the owner of the I-20 is Mr. H. Lalsota. Mr. H. Lalsota, which is at cross-examination part.
Who's cross-examination?
PW number 3, which is at page 11. Third line from the bottom, Your Lordship. Third line from the bottom. It is a fact that the said owner of the vehicle, fourth line, it is a fact that the owner of the said vehicle is H. Lalsota as per Vahan. So the prosecution knows that the vehicle is owned by Mr. H. Lalsota, because the problem is that he's a necessary party, because the two accused deny the ownership of the seized article. But the seized article were recovered from the back compartment of the I-20. At least he has to be called before the court to adduce the evidence, or he has to be arraigned as the accused, because his vehicle is using for transporting a contraband items. So the prosecution fails to implead the necessary party.
Yes.
Lordship, my second, the other point is that there is a clear violation of Section 52A of the NDNPS Act. The Section 52A has three purposes. One is inventory before the magistrate, and second is the photographs, and the third one is draw representative sample before the magistrate, Lordship. And the prosecution fails to prove that the drawing of the samples before the magistrate were, they have not exhibit, they are not a part of the charge sheet, it's not a part of the paper book as well, Your Lordship. So the drawing sample is not a part of the charge sheet, it's not available.
So samples have to be drawn in front of the magistrate?
Magistrate, Your Lordship, that has to be drawn. But it's not available in the paper book, it's not available in the charge sheet. And nobody had exhibited that this drawing sample. Then they have stated that they have drawn this sample from 80 soap cases.
Have you checked in the original record? Have you said original records were there? Was there?
Yes, sir. The sample were drawn on the spot, and
have you checked this original records?
inventory was made before the magistrate, and it was exhibited. And the inventory photograph, those were exhibited by the case IO, Your Lordship. It is very clear that in the examinations of the case IO, it has been done as per Section 52A guidelines.
That has been certified. Those have been certified.
Yes.
But not exhibit, Your Lordship.
It was exhibited as Exhibit P10.
It's, Your Lordship, available in the this additional paper book.
Your Lordship, if I may take you to page number 16 of the paper book, in order to make clear that grounds raised by the counsel for the appellant. Page number 16 in the exhibit part.
Exhibit 8.
Exhibit P10, P10A, B, C, and D are photocopied during inventory. And it can be seen in the record as well.
But thing is that now coordinate bench has already held,
I
very
understand
clearly
that.
held that the whole the procedure of there is a procedural lapse, and on that ground only that other person co-accused has been acquitted.
Yes.
Now what remains in this case?
My only objection is that there is a clear recovery. Clear recovery.
No, clear recovery, but
And there is a conscious possession which the
clear
appellant did not.
recovery, but conscious possession is the ground you have taken. But thing is that while sending to the FSL, while sampling while making inventory, there is, this is held by the court, this is held by a court that this is not done as per the law.
Yes, Your
So
Lordship.
in that situation, what can be done?
My another point is that the genuineness and the integrity of the
Then if you have any,
contraband was
if you
not
have,
challenged,
then
and
if you-
that was also raised in the earlier
Hmm?
in the earlier criminal application. That was also already raised, Your Lordship. I understand that. But however, Your Lordship, in the present case, the accused.
Only difference is that what I can see now, till now is that like there is a witness which says that has been put in the car by him, by this present appellant.
Actually, Your
Other than that, all facts are similar.
Yes, Your Lordship, all facts are similar,
All facts
but
are
the
similar.
thing is that the contraband article was seized from his possession, from the appellant.
No, it's recovered from the I-20, Lordship.
No, it is
No, Your
recovered-
Lordship, if I may take you to section, page number 13, it is very clear in this evidence.
No, if it is recovered also,
Yes.
if the proper process of seizing is not done, seizure is not done,
Yes, yes.
and there are these are statutory provisions. If any statutory provision is not complied with, then that vitiates the whole proceeding, and that
Yes.
has been held by this coordinate bench of this court.
Yes,
Now, if the
and-
the procedure is the same procedure, there is no different procedure adopted in as far as these two persons are concerned.
I
So if
understand that.
if the procedure adopted for one person is incorrect, then the same procedure will be incorrect for the other person also. There are no other additional material which will say that like no, the procedure is the separate procedure was adopted and that procedure is in fact correct. That has been done and complied as per the statute. That is not the case.
I understand
Then
that,
in
Your
that
Lordship.
situation, if you have some issues, then we could have in fact challenge this appeal. this.
Yes, I understand that. However,
Otherwise,
Your Lordship,
without having any additional material which really pinpoints this person, how this court is now going to take a different view than the view which has already been taken by a coordinate bench as
Yes.
far as the procedure is concerned. And as you know, in NDPS matters, the statutory procedures, any sort lapses because the rigors are very drastic.
yes, Your Lordship, in that regard, regarding the violation of certain procedure, where the foundational facts is proof, the core issue that whether the contraband article was seized from the conscious possession of the accused. If the foundational fact is proved, Your Lordship.
The foundational fact is not only the seizure. Foundational fact is seizure
possession.
while seizing the contraband materials, whether you have complied with the statutory provisions or not. That is the foundational
There is
fact.
a substantial compliance.
Yes, that is not in NDPS matter. There is nothing like substantial compliance. It has to be either compliance or non-compliance. There is nothing like substantial
I would like
compliance
to rely
in NDPS
to
cases.
one citation, Your Lordship, if Your Lordship kindly allowed me.
Yes, please.
Two 2025 8 SCC 452.
2000.
25 8 SCC 452.
Yes. What does it say? Para.
Para number 50. 50 50.
50. Yes. Let's see what does it say. Bharat Ambale.
Yes, Your Lordship. Well, I'm sorry, Your Lordship. Page, para number 56. If I may read out.
Yes.
We summarize
One
our
second.
final.
56. Huh?
Yes, para 56. This is the conclusion part.
Yes.
We summarize our final conclusion as under. Although Section 52A is primarily for the disposal and destruction of seized contraband in a safe manner, yet it extends beyond the immediate context of drugs disposal, as it serves a broader purpose of also introducing procedural safeguards in the treatment of the narcotic substance after seizure inasmuch as it provides for the preparation of inventories, taking of photographs of the seized substances and drawing samples therefrom in the presence and with the certification of a magistrate. Mere drawing of samples in the presence of a gazette officer would not constitute sufficient compliance of the mandate under Article 52A, subsection 2 of the NDPS Act. Although there is no mandate that the drawing of samples from the seized substance must take place at the time of seizure or held in Mohanlal. Yet we are of the opinion that the process of inventory, photographing and drawing samples of the seized substance shall, as far as possible, take place in the presence of the accused, though the same may not be done at the very spot of the seizure. Any inventory, photograph, or samples of seized substance prepared in substantial compliance of the procedure prescribed under Section 52A of the NDPS Act and the rules, standing orders thereunder would have to be mandatorily treated as primarily evidence as per Section 52A subsection 4 of the NDPS Act, irrespective of whether the substance in original is actually produced before the court or not.
Correct. That is why, I mean, when the materials are contrabands are seized, that is why inventory is prepared before a magistrate,
Yes.
photographs are taken, and
in the present case, it has been done.
Magistrate will certify those things. Then the primary evidence will be kept in Malkhana, and if the primary evidence is not produced before the court, also with the help of this inventory and certificate duly
Exactly.
given by the as per 52A by the magistrate can be held as substantial evidence.
Yes,
That
in
is
the-
there. That is there.
Yes, that is the ground raised by the appellant, Your Lordship.
No, that, I mean,
And another point, Your Lordship, if I may continue. 56.4. The procedure prescribing by the standing order rules in terms of Section 52A of the NDPS Act is only intended to guide the officers and to see that a fair procedure is adopting by the officer in charge of the investigation. And as such, what is required is substantial compliance of the procedure laid therein. Mere non-compliance of the procedure under Section 52A or the standing order rules thereunder will not be fatal to the trial unless there are discrepancies in the physical evidence rendering the prosecution case doubtful, which may not have been there had such compliance been done. Courts should take a holistic and cumulative view of the discrepancies that may exist in the evidence adduced by the prosecution and appreciate the same more carefully, keeping in mind the procedural lapses in the other material on record adduced by the prosecution, oral or documentary, inspired confidence and satisfied the court as regard the recovery as well as conscious possession of the contraband from the accused persons, then even in such cases the court can without hesitation proceed to hold the accused guilty, notwithstanding any procedural defect in terms of Section 52A of the NDPS Act. Non-compliance or delayed compliance of the said provision or rules thereunder may lead the court to drawing an adverse interference against the prosecution. However, no hard and fast rule can be laid down as to when such inference may be drawn, and it would all depend on the peculiar facts and circumstances of each case. Whether there has been lapse on the part of the police in either following the procedure laid down in Section 52A of the NDPS Act or the prosecution in proving the same, it will not be appropriate for the court to resort to the statutory presumption of commission of an offense from the possession illicit material under Section 54 of the NDPS Act unless the court is otherwise satisfied as regards the seizure or recovery of such material from the accused person from the other material on record. The initial burden will lie on the accused to first lay the foundational facts to show that there was non-compliance of Section 52A either by leading evidence of its own or by relying upon the evidence of the prosecution, and the standard required would only be preponderance of probabilities. Once the foundational fact laid indicate non-compliance of Section 52A of the NDPS Act, the onus would thereafter be on the prosecution to prove by cogent evidence that either there was substantial compliance with the mandate of Section 52A of the NDPS Act, or satisfied the court that such non-compliance does not affect its case against the accused, and the standard of proof required would be beyond reasonable doubt. So, Your Lordship, it is very clear in this
No, no, no. In
case.
your case, in your case, other than section 52A,
I understand that. My only objection is that, Your Lordship,
this case says about 52A only.
the reliance made by the appellant, and that in that case, even though they were in the same case, but the evidence against them are different, because it is very clear that the present appellant is caught red-handed while he was carrying that contraband articles. But in the co-accused, regarding the co-accused, he was not caught red-handed.
But
He's the only driver.
he was supposedly driving the vehicle.
Yes, and Your Lordship, only once if I read out the evidence of this PW number 4.
Yes.
That is in page 13.
Page 13.
Yes, 1-3.
One second. Page
1-3, 13.
Yes.
I know the accused person. I stood before the court today in my capacity as prosecution witness. On the night of 26/4/2023, I was on duty at Tuisan Pai check gate. At the offended vehicle Hyundai i20 driven by accused Joseph Lalding Heta proceed towards Aizol, reached the checkpost, and the driver stepped out of the vehicle and checked in. He was extremely terrified, and out of fear, he made voluntary disclosure statement that they are smuggling contraband items with the co-accused Lalruat Sanga. While co-accused Lalruat Sanga walked by foot to avoid the checkpost. We then informed the seizing officer, and on his command, we followed the accused Joseph Lalding Heta, and when we reached the place where the accused Lalruat Sanga would join him back, we waited for some minutes, and as soon as the accused Lalruat Sanga arrived back, we halted him without conducting search and waited for the seizing officer. After the arrival of the seizing officer, search was conducted, and we recovered 80 soap cases containing brown powder suspected to be heroin wrapped in one green sataip from the back carrier of one vehicle, I-20 car bearing so-and-so. So, Your Lordship, in the cross-examination, if I may read out. It is a fact that there were 2 constables on duty at Tuisan Pai check gate, and I was one of them. It is a fact that the vehicle reached our check gate at around 11:30 to 12 night. It is a fact that we were not given orders by anyone to accompany the accused on the back seat of the car. Here, the accused whom they accompanied is the co-accused. It is a fact that our main intention was to wait and nap for Lalruat Sanga and not to have a fun ride with Joseph Lalding Heta. It is a fact that we apprehended the accused Lalruat Sanga around 2 kilometers away from the check gate. We were waiting for the accused Lalruat Sanga for around 3 to 4 minutes at the spot where we had a stakeout. It is a fact that the accused Lalruat Sanga was carrying the contraband articles in a sataip, that is plastic sack, and I believe it to be number 4. It is a fact that the said sataip...
What is this number 4?
Heroin number 4. It is mean to say that heroin number 4.
Okay. Okay, heroine number 4. Okay.
It is a fact that the said sataib, that is plastic sack, was not transparent so as to enable us to see whether the sack contained heroin. It is a fact that the said sack was carried by the accused Lalrosanga with his hands. It is a fact that we do not weigh the seized article at the spot. It is a fact that we gave information after we reached our check gate. It is a fact that I do not know who prepared grounds of belief at the spot, so and so. So, Your Lordship, it is very clear in this evidence that he was caught red-handed, and this evidence was never rebutted by the accused during the whole trial, and even at this time, no rebuttal was made in accordance with this evidence. So the principle of parity cannot be applied in the present case because the role and the circumstances were completely different. So my submission is
The
that
role and this thing is that is fine.
and with regard to
But the other case, the acquittal was only on the basis of the procedural lapses.
I understand.
Then that is the thing now, which will how this can be distinguished. How this case can be distinguished from the other case.
From the evidence only.
Correct. How it will be done? Once it has been held that the procedural lapse is there.
Yes, that
the
is my
same
argument, Your
procedural
Lordship.
lapse.
And with regard to parity, I would like to submit one citation again, Your Lordship,
Yes.
for the sake of argument, Your Lordship.
Yes.
2025 SCC Online, SC 2584.
2000?
2025
Uh-huh.
SCC Online, SC 2584. Para number 1414.
Okay.
If I may read out.
Yes.
What flows from the above judgment, which have been referred to only to the limited extent indicated above, is that the High Court speak in one voice that parity is not the sole ground on which bail can be granted, that undoubtedly in the correct position in law, the word parity is defined by the Cambridge Dictionary as equality, especially of pay or position. When weighing an application on parity, it is position that is the clincher. The requirement of position is not met only by involvement in the same offense. Position means what the person whose application is being weighed, his position in crime, that is, his role, etc. There can be different roles played. Someone part of a large group intending to intimidate or instigator of violence, someone who throws hands off at the other side, instigate by such words spoken by another, someone who fired a weapon or swung a machete. Parity of these people will be with those who have performed similar act and not with someone who was part of the group to intimidate the other by the sheer size of the gathering, with another who attempted to hack away at the opposer's limbs with a weapon. So parity has to be determined regarding their roles in each case. That is my submission.
Also, may I continue?
Is there anything more to submit?
Yes, Your Lordship. I'm not completing my submission, so my
Yes. Yes.
Lordship,
No,
this
your submission is only the same submission that has been made in the other case.
yes, Your
What
Lordship,
else?
and besides that, there is a chain of custody is also broken, Your Lordship. The chain of custody
What
is also
custody?
broken.
What
Lordship,
custody?
may take Lordship to the additional paper book. Additional paper book, Lordship, is available. Yes,
One second.
additional.
One second.
This is since in the paper book some of the
1 second.
yes, sir.
Yeah, NDPS Act is, excuse me, NDPS Act. So you are saying that like 80 samples were taken, only 8 samples have been sent.
Very true, Your Lordship. It has been sent, and the record says that it was sent to the FSL on 27/4/2023. 27/4/2023, but the same was received by the office of the FSL on 5/5/2023. There is a gap of 8 days. Nowhere in the evidence explains such 8 days lapses, Your Lordship.
Whether it is fatal.
It is. It says that it was packed, but the whereabout is not known, and there is no explanation at all.
It may be on transit.
No, it is Lordship.
Where is that FSL is located?
FSL is located here in Aizawl, and this article was kept at the police station, which is at Kozol, which is 120 kilometers away from here. 2.5 hours maximum driving, 2.5 hours. So it takes 8 days. So it is not known, and that was also one of my submission, Lordship. And may take back to the judgment and order passed by the coordinate bench, Your Lordship. Page 10, paragraph 18. Page 10, paragraph 18. Page 10, paragraph 18.
Yes.
Yes, the Lordship, here this 2025 8 SCC 452 was
This has been referred to.
This is relied by my learned friend, and it was squarely considered by the coordinate bench, Lordship. And Lordship, in this judgment, paragraph 29, page 21. Paragraph 21, page 29. May I read again? Lordship. As a consequence of the above discussion, this court is of the opinion that the failure on the part of the seizing officer to send the full report of the arrest and seizure to his superior officer within 48 hours, the gaps in the chain of the custody with regards to the seized article, the inability of the independent witnesses and the IO to prove the recovery from the accused person, the non-production of the certified list of samples drawn from this seized item, the non-production of the...
But in your case, the IO to prove recovery
No,
is
Lordship,
done from...
it's not proof, Lordship. Here the IO had stated that it was personally carried by me. But all the other evidence has says that it was recovered from the
Back of the vehicle.
Back of the vehicle. So here it's that has also been considered by the coordinate bench, Lordship,
Where?
which is at page 19. Page 19.
Yes.
Third line from the top, Lordship. The PW number 4. Lordship, got it?
PW number 4 is who?
PW number 4 is the IO, who is accused that I'm carrying that contraband items. Oh, he's the person who.
PW4 is not at all
number
clear
4 is
whether.
Yes, PW4 is the person who accused me carrying the contraband articles.
Carrying the contraband articles by the vehicle, not by physically by you.
Yes, yes. And here it says that PW number 4 is not at all clear that whether the seized article were recovered from the co-accused, which is me, Your Lordship, the co-accused, who was carrying it in a plastic sack, or whether the co-accused, which me, kept the plastic sack in I-20 vehicle, then it was recovered from the vehicle.
Let us see PW4.
PW4, Lordship, yes. Which my learned friend had read out the earlier, Lordship.
So let us see it once again.
Page 13, 1-3. May I read, Lordship?
Yes.
I know the accused persons. I stood before the court today in my capacity as prosecution witness. On the night of 26/4/2023, I was on duty at Tuipuisen check gate. At the offended vehicle, Hyundai I-20, driven by the accused, Joseph Lalding Heta, proceeding towards Aizawl, reached the check post, and the driver stepped out of the vehicle and checked in. He was extremely terrified, and out of fear, he made voluntary disclosure statement that they are smuggling contraband items with the co-accused, Lalruat Sanga. Lalruat Sanga is, it may be a typing mistake, Your Lordship. It should be Lalruat Sanga. While the co-accused Lalruat Sanga walked by foot to avoid the checkpost, we then informed the seizing officer, and on his command, we followed the accused, Joseph Lalding Heta, and when we reached the place where the accused Lalruat Sanga would join him back, we wait for some minutes, and as soon as the accused Lalruat Sanga arrived back, we halted him without conducting search and waited for seizing officer. After arrival of the seizing officer, search was conducted, and we recovered 80 soap cases containing brown powder suspected to be heroin wrapped in one green sataib, which is a plastic bag, from the bag carrier vehicle I-20, bearing registration number such and such.
So this is clear that it was recovered from the I-20, which was driven by both the co-accused. One was, obviously the vehicle was driven by one, and one was a co-passenger. Correct. This is clear from here.
Yes, yes.
Now you tell me which witnesses state that like, it was kept in the, it was carried by him and like kept in the.
Recovered from the.
Yeah,
I take Lordship to the.
PW.
Start from the PW number. Yes, PW number 2. Yes, PW number 2.
PW
is the
number
civilian
2.
witness.
What did he say?
Which is at page 9.
Yes.
I know the accused person, that is his deposition. I stood before the court today in my capacity as Caesar witness. On this such and such at night, I was called by Kuzol police to witness search. When me and my co-witness Vanal Ven Hima reached the place of occurrence, the seizing party recovered and seized 80 soap cases containing brown powder suspected to be heroin wrapped in one green sataib from the bag carrier of one vehicle I-20, bearing registration number such and such.
So this corroborates.
This corroborates in the sense that it has been recovered from the back seat,
not
from me. It's not from me.
No, it has been recovered from the vehicle.
From the vehicle.
Vehicle driven by. Is there any rebuttal that you were not driving the vehicle, or
I'm not driving.
You were not there in the vehicle?
I am not there in the vehicle, Your Lordship.
How? Where from? Where you're saying?
Here, it's PW number 4 had clearly stated that.
You stop. PW4 stated that when the checkpost was about to be reached, you came out of the vehicle and you started walking. Then they waited for you to come back. Then when they came back, the charge was made.
That is
so you were there in the vehicle.
I may be or may not be, Lordship. That is not.
There is no question of
evidence, Lordship.
No, you show me from record that you were not there in the vehicle.
Lordship, there is no evidence. Lordship, there is no evidence.
There is evidence that there is evidence of PW4 that you were there in the vehicle.
Lordship, as per my understanding, there is no evidence or
no,
statement to
I am
show
saying this court is saying that there is a clear evidence saying that you were there in the vehicle. You stopped the vehicle before reaching the checkpost. the person who was driving the vehicle, he disclosed that there was some contraband. You yourself, you went walking to certain place, then you came back again. And when you reached that spot, the search was made. And when the search was made, this contraband was recovered from the I-20 vehicle that was used by both of you. Now, how can you say from records that you were not there in the vehicle? You show me from any evidence.
Lordship, there is no such kind of evidence.
Then-
But Your Lordship, my submission is the statement or the evidence adduced before the trial court shows no evidence to show that the appellant, the present appellant, me, kept that SA in the I-20, Lordship, which was
What-
recovered. There is no evidence to show that the contraband item was kept in the I-20.
I mean, who will know it? You were driving the vehicle. This is your vehicle.
Also, it's not my vehicle.
Yeah, but
I'm
you,
the passenger.
you were
I'm a
using that.
co-passenger.
You are using that vehicle.
I'm Lordship, yes.
You are using that vehicle. That means that is in your conscious position. I mean, you can't deny that.
And
Now,
Lordship,
only thing is that you cannot escape the thing that the contraband was seized from the vehicle used by you. That you cannot escape from the
Lordship.
evidence.
But there's
Now,
no evidence to show that yes.
only thing is that
Yes.
now procedural thing.
Yes, yes.
Procedural lapses. Now, procedural lapses. You tell me what are the procedural lapses?
Lordship, the number one which I have
You
stated
forget
is
about the case which has been, which judgment, wherein the judgment has been passed.
Lordship.
You tell me independently which are the lapses.
And Lordship, I have already narrated that regarding this go down in Malkhana.
You take me to the sections. Take me to the relevant provision.
Lordship,
of
before coming to that, I may be
Then
allowed
you
to.
take me to the relevant provision of NDPS Act, how seizure has to be done and how it is to be seized and how it is to be destroyed. Once it is inventory is made before the magistrate, if it is required to be destroyed or not. Destroy when you destroy, when there is a need of destroying it, right?
Lordship, yes.
I mean, if the quantity is small, you can easily kept in the Malkhana.
Very
There is
true.
no problem. Then there is no question of destroying it. If it
Right,
can
right,
be
right.
kept in a safe custody. The question of destruction comes if it is a huge quantity. It's difficult to kept it there.
Very true,
If there is a
Lordship, yes.
chances of stealing those or getting destroyed. So in
Yes,
that
yes.
case, if inventory is made properly as per the statutory provisions of the NDPS Act, then that can be termed as a primary evidence. That is the law. Now you show me the sections. Which are the sections?
Lordship, this
Which are the sections whereby a seizure has to be made?
seizure has to be made, Lordship.
See, you are arguing that there are lapses in procedural. There are procedural lapses.
Very true,
In
Lordship.
seizing the quantity from your vehicle, right?
Very true.
Your vehicle or somebody else's vehicle. I mean, whatever. The seizure was not made as per the terms of the statute. You tell me now which provision you are relying on for that.
Lordship, I may be submitted this notification.
Section which under which section the notification is issued? Is it a new notification which is not there in the Bear Act?
Lordship, this
This is a notification of
This is a
2022.
notification, Lordship, which
Okay. Whether this notification is relevant at that point of time when the incident happened?
yes, Lordship.
When the incident happened?
It's in 2023, Lordship.
Huh?
2020.
When the seizure was made?
Lordship, seizure was. I'm sorry, Lordship. It's
26/4/2023. When?
this rules is 20. This is a 2022, Lordship. This is a 2022 notification, and the
No, no,
seizure was made on
notification,
2023.
Notification, I understand. I can see it from here. You tell me when the seizure was made.
Seizure was made on 26/4.
26/4
2023.
on the very same date when the affair was lost,
Yes,
right?
yes.
So whether this notification was relevant?
Yes, Your Lordship, this is 2022
No, it may
notification.
be 2022. There are a lot of notifications keep on coming. Are you sure that this is relevant?
As my understanding, Your Lordship, it's very much relevant. There is no other notification to rely upon.
This is notification dated 23rd December.
23rd December 2022. Since the seizure was made on 2023, as per my understanding, this is relevant.
Yes, this is there in the Bear Act itself. Yes.
Yes.
No, yeah. You take me to the relevant provision.
Lordship, yes. Regarding seizure and storage of the seized material, which is at Chapter 2, Lordship. Chapter 2.
Chapter 2.
Chapter 2, and the relevant is, Lordship, Chapter 3, sampling.
Seizure and storage of seized material.
Lordship, yes.
Classification of seized material. The narcotic drugs, psychotropic substances, and controlled substances seized under the Act shall be classified based on physical properties and results of drug detection kit, if any, and shall be weighed separately. If the narcotic drugs, psychotropic substances, and controlled substances are found in packages or containers, such packages and containers shall be weighed separately and serially numbered for the purpose of identification. All narcotic drugs, psychotropic substances, controlled substances found in loose form shall be packed in a tamper-proof bag or in a container, which shall be serially numbered and weighed, and the particular drugs and date of so and so will be given. Provided the bulk quantities of ganja and so, provided so. The classification, weighing, and packaging of numbers referred to in sub-rule shall be done in presence of such witnesses and person whose possession the drugs and substances are recovered. A mention to this effect shall be variably be made in the Panchnama. So you tell me, like, I mean, whether this has been complied or not.
Also, as per my understanding, that weight separately and serially numbered for the purpose of identification is not complied with.
No, sir. So see, there are 80 soap cases.
Soap cases.
So there is no, I mean, need of, I mean, doing it separately. It's already separate. 80 cases are there. You just need to weight those 80 soap cases with or without the soap case. The weight has to be done, and it has to be sampled and numbered. Whether that has been done in your case or not.
But Lordship, those representative sample drawn before the magistrate was not produced before the magistrate, because there is no signature.
No. The question of magistrate hasn't come as yet. Where is the question of magistrate here?
And Lordship,
while seizing,
Yes.
while seizing, it may not be always possible that a magistrate is present. Now,
but it has to be numbered properly, Lordship.
that is why I am asking.
Weight separately is also not found, because the total weight is also reflected in the evidence adduced by all the independent witnesses.
No, that is why I am saying, where you show me from your case that it was not done properly. You take me to the relevant documents. You take me to the relevant documents, the seizure memo and the process that they have followed.
Yes.
You show me that that process is not followed in terms of this.
Page 30. Also, but page 31, yes, 31, 32.
Page 31.
Page 31 is the seizure. And the relevant is at page 32.
So 80 number of soap cases suspected to be heroin number 4, weighing 894.18 grams total. But there is, of course, there is no mention whether it is weighed with the soap cases or without soap cases.
Lordship,
It looks
yes.
like they have done it with the soap cases. The suspected to be heroin number 4, 18 numbers of soap cases, so and so, exhibit 1 to exhibit 80, packed inside soap cases, the valued at so and so.
That is the only evidence.
Unlawful possession, 18 number of soap cases containing brown powder, suspected so and so, 18 number so and so. So what is wrong in this now?
Lordship, here, as per my understanding, there is no written that it has to be weighed separately because it was recovered from the 80 soap cases. So it is not known what is the weight of the each soap cases because it was weighing totally, Lordship.
Yes.
And Your Lordship, my next point is that at chapter 3, paragraph 10, drawing the samples. Drawing the samples, Lordship. Chapter 3, paragraph 10.
Yes.
Lordship, here it says that one sample in duplicate shall be
Where,
drawn.
where are you reading?
Lordship, chapter 3, sampling. So in
Section, rule.
10, Lordship,
Rule
drawing
10,
the
yes.
samples. One sample in duplicate shall be drawn from each package and container size. Number 2, when the packages and containers size together are of identical size and weight bearing identical marking and contents of each package gave identical results on color tests by the drugs identification kit, conclusively indicating that the packages are identical in all respects. The packages and containers may carefully be bunched in lots of not more than 10 packages or containers, and for each lots of packages and containers, one sample in duplicate shall be drawn. Also here it clearly says that it should be bunched in lots of not more than 10 packages or container, and for each lots of packages and containers, one sample in duplicate shall be drawn. And provided that in case of ganja, poppy straw, and Harris, it may be bunched in lots of not more than 40 packages or containers. In case of drawing sample from a particular lot, it shall be ensured that representative sample in equal quantity is taken from each package or container of that lot and mixed together and make a composition whole from which the sample are drawn for that lot.
So in your case, there are 80 packages, right? So they have made a bunch of eight packages, 10 packets each, and from each 8 package, 8 samples have been sent. What is wrong in that?
Lordship, as per my understanding, that has been bunched into.
See, these soap cases are identical. The powders they are identical. So they have made 8 bunches containing 10 soap cases each.
But Lordship, it is not known.
Just listen to me.
Sure.
8 bunches of 10 containers each, and from each from each bunches they have taken out one sample. So they have sent 8 samples to the FSL. So what is wrong in that?
Lordship, that part regarding that,
It says that when the packages and containers seized together are of identical size and weight, bearing identical marking, and the contents of each package give identical results on color test by the drug identification kit, conclusively indicating that the packages are identical in all respects. The packages and containers may carefully be bunched in lots of not more than 10 packages or containers, and for each such lot of packages and containers one sample in duplicate shall be drawn. So in your case there are 80 so cases,
80
so
soap
they have
cases,
made
true.
it to 8 bunches of 10 containers, and from 8 bunches they have sent 8 samples from each
Lordship,
bunch.
I think that is a presumption, Your Lordship. My submission is that even the case IO has not stated anywhere in his deposition that it was bunched on into the 8 packages, Your Lordship. There is no evidence, Lordship. That is my submission.
Learned APP, is there anything like that?
Yes, Your Lordship, in that regard, there is no mentioning. However, Your Lordship, there is no question asking whether there is a bunching or not. That question remains silent. And even the counsel for the appellant during trial, they had not raised that question in order to clarify that whether there is a bunching or not. So, as it can be seen that there is 80 soap cases and 8 samples were drawn, it can be seen that there is a bunching, Your Lordship.
Come to page 40. So this certificate is issued under for 52A.
52A, Lordship. Yes.
So
the-
is there any problem in this?
Lordship, this is after 52A, there should be an application first, and that will be allowed by the magistrate. Lordship,
No.
here the problem is there is no application annexed in this, and besides this inventory, there is no other has been annexed in the charge sheet or as well as in the paper book, Lordship. And my learned friend had stated that all of them have been exhibited, but the document shows that it was not exhibited. Here the case IO had stated that it was exhibited as exhibit.
Let us see the
B10.
charge sheet. Let us see the charge sheet.
Charge sheet.
Sign.
No. Exhibit. Where is the exhibit? No exhibit. Signed but not exhibited.
Oh, original.
See, though the process has been narrated by the coordinate bench, the only paragraph which has actually dealt with the recovery and on is paragraph 25. And as far as compliance with section 52A NDPS Act is concerned, the same is vital in the instant case, as the seized articles were never produced physically before the trial court. But I think that is not required.
Lordship, I may be
You have a
allowed to
problem,
produce some
Mr.
citation.
You have a problem.
Lordship, I may be allowed to produce some citation regarding that.
You do one thing. You come prepared. We'll fix it in the next on the next week sometime. Both of you will come prepared, because see, I mean there there is a coordinate bench judgment, so we cannot go. I mean go here and there much. But only thing is that there are some issues which are involved. So you don't have a cakewalk in this case. You may not have a cakewalk in this case, right? First of all, you'll have to convince this court that there was procedural lapses, that there was evidence that that the contraband materials were in fact not recovered from you, from your conscious position. You have to bring in case laws. You just can't come here and like submit. You'll have to show, I mean, when you are driving a vehicle and a vehicle is stopped and contraband materials were seized from the vehicle, whether you can deny that I don't have any knowledge about those materials which were found in the vehicle, whether you can take that plea. If you think that you can take that plea, bring some case laws from where you can say, in spite of driving the vehicle, in spite of traveling in the vehicle, you can still say that that was not in your conscious, not from your conscious position. Because see, from the evidence, it is clear that you were driving that vehicle. You were there in the vehicle. That PW4 is specifically stated. And you could not rebut his statement. There was no defense, rebuttal, which is required. There is nothing on record. So, if you were there in the vehicle and the materials have been recovered from your vehicle, and then the recovery is proved, and if recovery is proved, then only thing remains is that like whether the seizure was done as per the procedure or not, whether the FSL report was properly done or not, all these procedural aspects. So procedural aspects you'll have to show and convince this court that the procedural aspects were not relied, and that APP has a duty that to convince this court that that prosecution has done all the things which are required to be done while seizing this. You have a bigger duty. So come back with your these things. We'll fix it on. You can write heard Mr. So-and-so, the learned counsel appearing for the appellant, also heard MS so-and-so, the learned APP for the state. The hearing remained incomplete. Let the matter be listed on when 21st 21st of June,
Yeah,
or 23rd of June.
23rd, yeah. Lordship.
No, it's 23rd.
Sorry, 23rd of June, huh?
Yes, Lordship, 23rd.
23rd of June. So come back with some preparation.
Part 2, item number 4.
Okay.
This is the, my lord, the bypassing the impugned judgment and order by the Fast Track Court of Scholarship District on 9/4/2024, my lord. The appellant was convicted under 21C of NPS Act, my lord, to undergo imprisonment of 10 years and to pay a fine of rupees 1 lakh. And in default
Just
of
put the slip in the other case. The earlier case, no? Excuse me, let's put some water. Yes.
And my lord, in default of payment of fine of rupees 1 lakh, and in default, he has to suffer another rigorous imprisonment for a period of 1 year. My lord, here the story starts from the report submitted by the Sub-Inspector of Excise and Narcotics Department at Colosseum, submitting to the officer in charge of Excise and Narcotic Department, Colosseum District, on 28th March 2021, regarding the seizure and arrest of the contraband, which was...
Where is that?
This is at page 67 of the paper book, my lord.
Page 67.
67. If I may read, my lord.
Yes. There is no type copy of this.
It seems that there is no type copy, yes. It may be a bit difficult to read, but that I can read, my lord.
Yes.
To the officer in charge and so, subject report of seizure and arrest with a prayer to register case against the accused. Sir, with due respect, I have the report that on 20th March 2021 at 4:30 p.m., I seized 324 grams of yellowish powder suspected to be heroin, that is 166 grams, S1 to S13 and 158 grams, S14 to S26, kept in 26 soap cases, concealed in white polythene, further concealed in a black color backpack at Bukpui, Ral Bomram, that is 8 kilometers away from Bukpui village, Kolasip district. I also arrest the possessor, Zarzawa, age 45, son of Tlankuma, so-and-so, Aizol district, and Lal Duoma, age 25, son of Thangmoya, so-and-so, Aizol district, on the same date, place and time, in presence of reliable civilian witnesses. The seized article was recovered besides the accused while they try to make transaction at the place of seizure. Seizure and arrest intimation was given to their relatives through their phones, either for prayer or kind authority to register case against the said accused under appropriate section of law. This is, my lord, the report of seizure and arrest submitted by the Sub-Inspector Efel Nunkluanga to the officer in charge of Excise and Narcotics Department on 20th March 2021, my lord.
20th March? 21st March?
20th March.
20th March 2021.
As per the signature given.
Yes.
And my lord, here there is a note written on the body of that paper, duly signed by the officer in charge, Excise and Narcotics, on 21st March 2021, writing that a case is registered against them under excise case number so-and-so dated 21st March 2021 under section 21C of NDNPS Act 1985. And case is endorsed to SI Lbiak Lunaralte for further investigation.
Yes.
This is the report of seizure and arrest, my lord. And here, my lord, if your lordship may kindly see the page 68 of the paper book regarding the seizure and arrest memo. This
Yes.
is the seizure and arrest memo duly signed by the sub-inspector who had reported the seizure and arrest to the authority. If I may read, my lord.
Yes.
SI Evelyn Nuntluanga of Excise and Narcotics Department, Anti-Narcotics Squad do hereby seized the below mentioned illicit article on 28 March 2021 at 4:30 p.m. at Bukpui, Ralbomram, 8 kilometers away from Bukpui, Kolosip district. I also arrested its possessor, Zarzo of 45, son of Tlankuma so-and-so, Aizol district, and Lalduoma 25, son of Tangmoya, so-and-so Aizol district, on the same date, place and time in presence of the undermentioned reliable Sylvian witnesses. Intimation of seizure and arrest was given to their respective relative from Lalduoma's phone on the spot. Here the seized article is written as 324 grams of yellowish powder suspected to be heroin, 166 grams S1 to S13 and 158 grams S14 to S26, kept in 26 soft cases concealed in a white polythene and a black color black bag. Here the witnesses, the civilian witnesses, had given and had put their signature. Si Vanal Moya, son of Frank Nilawa, Buk Pui Mualveng, phone number is given, and H. Zel Siama, son of H. Kum Tangabuk Pui Veng Sang, had given their signature. And my lord, after this, the complaint was submitted by the investigating officer, Sri Lalbiak Lunaralte, which is at page 69, my lord. If I may read, my lord. The brief history. The brief history of the case is that on 20th...
This is what? This is the complaint? No.
This is a part of the charge sheet, my lord. Part of the charge sheet. Under section 190 of CRPC.
Okay. Yes.
The brief history of the case is that on 28 March 2021 at 4:30 p.m., Sub-Inspector of Excise and Narcotics Evelyn Nuntluanga, Anti-Narcotics Squad and Party performed duty at Ralbomram, Bukpui area, and they had arrested Zarzo of 45, son of Klankuma, Mauchar Vengchak, Aizol district. Number 2, Lalduoma, 25 years, son of Tangmoy, Mauchar Vengla, Aizol district, in connection with the seizure mentioned in column 3 of this sheet. The said accused persons were sent to the district hospital, Kolosip, for medical examination, and the examination report shows that they were medically fit to be kept in the custody. He also submitted the report of seizure and arrest to the OC, Excise and Narcotics Station, Kolosip, and a case number so-and-so, dated 21/3/2020. It was written like 2020, Malo. But the arrest date is 2021. It might be a typical mistake. Under Section 21C of NDNPS Act, 1985 were registered against the said accused person, and I was endorsed the case for further investigation. During the course of my investigation, I examined the accused persons, seizing officer, and the witnesses. I also recorded their statements under good atmosphere. I also sent sample of the seized articles at FSL, and the result shows that the purity of the seized heroin were 77% at the time of examination. And I also visited the PO along with seized witnesses. My investigation reveals that The seized articles were recovered from the possession of the true accused persons while they tried to hand it over the seized articles to another person. The true accused were brought the said articles from Mauchar and they were arrested at the roadside of Serkantubaga Road, 8 kilometers away from Bupui. They stated that this is a Mizo vernacular, my lord. Heng dam doi te mau chara trangin midang kuta lan tura kankin.
What does it mean?
Meaning that they are planning to hand over to some other persons by bringing that contraband from Mauchar village. And while we are about to hand over, they
have been caught.
Yes, that was like that. Hence, I found a prima facie case well established against the said accused persons under 21C of NDNPS Act 1985, and I charge them accordingly for violation of Section 8C of NDNPS Acts. My lord, here as per the charge sheet, it can be seen that what was written was that the true accused persons, while they tried to hand it over the seized articles to another person, while they brought the said articles from Mauchar village, they were arrested at the roadside, in between villages, in the highway, my lord. That is what was written in the charge sheet, my lord. And my lord, here the information report was prepared by the sub-inspector who had arrested and seized the accused persons, which is at page 70 of the paper book, my lord. Here the information report date was given like 19 March 2021. 19 March 2021. Here it is written like this. On 19th March 2021, I received reliable information from 46th Assam Rifles about bulky transaction of suspected heroin at Kolosip area. Based on that, I with my duty party went to the said place in pursuance of the said report. This is the information.
So it started from this actually.
Yes, this is the main information actually. Information received from, it seems that as per this information report, received from the 46 Assam Rifles. This is what is written. And my lord, with regard to the charge made under 21C, and in order to prove the allegation, the prosecution had examined the prosecution witnesses, which is at page 22 of the paper book, my lord. Here, the PW1 and the PW2 are the civilian witnesses.
PW1 and PW2.
PW1 and 2.
So how many witnesses were there?
There are 5 PWs, my lord.
5 PWs.
My lord. If I may read the deposition, my lord.
Yes.
At page 22. 22.
Yes.
On 20th March 2021 at around 4:30 p.m., the excise personnel seized 324 grams of yellowish powder suspected to be heroin kept in 26 soap cases from the possession of Zarza Wasonov, Tlankhuma, and Laldo Masonov, Thangmoyat Bukpui, Ral Bomram. The accused were also arrested at the spot. I was present when the seizure and arrest were made, and as such, I stood as a witness. Exhibit P2A is my signature. On cross-examination, my lord, here the cross-examination is like this. It is a fact that I denied that I was inclined towards the excise personnel. It is a fact that I do not know that the seized article belonged to the accused. It is a fact that I deposed truly before the court today. This is the only statement and cross-examination of the PW number 1. He do not know that the seized articles belong to the accused. It is not in his knowledge. And my lord, at page 23,
He is the Caesar witness.
yes, he is the Caesar witness. Caesar witness, but he did not know whether the seized article belonged to the accused or not. He did not have that knowledge. And PW2 is also the Caesar witness, my lord. His name is H. Celsiama, age is 46 years. And he stated like this, my lord. On 23/2021, at 4:30 p.m., the excise personnel seized 324 grams of yellowish powder suspected to be heroin kept in 26 of cases from the possession of Zarza was son of Tlang Puma and Laldu son of Thang Moya at Bukpui, Ralbom Ram. The accused were also arrested at the spot. I was present when the seizure and arrest were made and asked to...
So there is he has made a specific statement that has been seized from the possession of these two persons. The only thing he is saying that they are saying, both of them are saying that we do not know whether that belongs to them or not. But as far as the possession is concerned, that has been recovered from him. That is there. Correct?
Correct, my lord. That is from the actual reading of the evidence.
So I mean, there may be something which has been taken from me, seized from me, but from as far as like it has been seized from me, there is no doubt. But whether the thing belongs to me or not, he doesn't know.
Correct.
That is what he said.
That is correct. That is from perusal of that PW1 and 2.
Yes.
That is the
Yes.
situation.
So as far as possession is concerned, there is no denial. Only thing is that whether that belongs to him or not, he is not aware of. Obviously, he will not be aware of whether that belongs to that person or not. Yes, correct.
My lord, if I may go to page 24, my lord, PW3. If I may read, my lord.
Yes.
I know the accused persons. They are the person from whom the essay were seized. On 19/3/2021, I received a reliable information from 46 Sam Rifle about bulky transportation of suspected heroin within Kolosip area, and based on that, I, along with party, went in pursuance of the report. On the next day, that is 20th March 2021 at 4:30 p.m., I seized 324 grams of yellowish powder suspected to be heroin, kept in 26 of cases, concealed in a white polythene and a black color backpack from the possession of both the accused, Zarza was son of Tlang Huma and Lalduoma son of Thang Moya at Bukpui, Ralbomram. The arrest and seizure was made in presence of independent civilian witnesses. Intimation to the relatives of both the accused had been given through the mobile phone of the accused Lalduoma. On the same day, I submitted report of the seizure and arrest to the OC, Excise and Narcotics, Kolosip. Exhibit P and P4, so and so. These are the signature and the seizure and arrest memo are exhibited. In the cross-examination, it is a fact that the essay were not seized from the physical possession of the accused. There was a contradiction, my lord, here. He stated that the essay were not seized from the physical possession of the accused. And
You have the originals of this?
This is correct, my lord.
Is this correct?
Yes, my lord. Physical possession means he was not holding the essay. This, it's in the next line. It was seized from a vehicle.
Okay.
at serial number 2, it is a fact that the essay were seized from a vehicle Renault Kwid, but I could not recall the color of the vehicle. Page 25. It is a fact that the accused Alduoma was not sitting inside the said vehicle. It is a fact that one person other than the accused Arza was sitting inside the said vehicle, from where the said seized article were recovered, and the said other person was not arrested by me. It is also a fact that the said vehicle was not seized by me. It is a fact that the place where seized article were seized is not ISOL jurisdiction. It is a fact that before giving written information to Excise and Narcotics, Scholarship, I seized the seized article. I also arrested both the accused. And in the re-examination portion, in respect of para 2 and para 4 of the cross-examination, as the person inside the car was a decoy customer and the said car has been used by him, I did not seize the car and arrested the said decoy customer. And on further cross-examination, it is a fact that I do not have the documentary proof that the said vehicle and the person sitting inside the car was a decoy customer and a decoy vehicle. So, my lord, what can be seen is that the evidence of the PW number 3 is there was a contradiction.
Which contradiction?
With regard to the evidence of the PW 2 and PW 1.
Why? How?
Stating that the vehicle, I mean the seized article were not seized from the physical position of the accused.
Correct. He has clarified it that it has been, it's not from my pocket, but it was there in the vehicle.
It was stated that it was seized from the vehicle. That
correct. So that he has clarified. So physical position, he is meaning that not from his physical position. Something which is in your pocket, that is in your physical position. Something which is lying on your vehicle, that is not from your physical position, but from the vehicle. That he has clarified. So there, I don't think there is any contradiction in that. Yes, we'll take it up at 2 o'clock.
Malo.
I will continue. 2 o'clock, there is some other matter. There is one matter is there. Then after that matter, we'll take it up.
Malo.
should we do the Kohima first?
Yeah, let us take the Kohima first. We'll have to wait for some time. There's another matter fixed.
Item number 1, review pet.
May I please, Your Lordship?
Yes.
Lordship, Your Lordship, by judgment order 24/10/2025.
Yes, what is wrong there?
It was dismissed on the ground of delay in legis, Your Lordship.
Yes, it was 30 years delay.
Your Lordship, we have placed before Your Lordship the two judgment, Your Lordship. We have placed before two judgment, Your Lordship.
What?
Two citation, Your Lordship.
What citation?
One that is page 40 in Excerpt 3. Page 40, Your Lordship.
Page?
Page 40, 40.
40.
Yes, Lordship.
Yes, what is that case?
Here, Lordship, the appellant husband who was working as a gangman in railway. He died in the year 1969, and the appellant approached the Honorable Court only in the year 1992, after a lapse of almost 2 decades.
But in this case, the person was regularized, and she has come for pension benefits only. But in your case, your post was not regularized.
Lordship, then I may be allowed to take you to page 27, Your Lordship.
27, what is that?
Page
Whether
27.
your post has been regularized to get pension.
Yes, Your Lordship. That was...
No, whether your post has been regularized to get pension.
No, Your Lordship.
Then when your post is not regularized, how will you get pension? First of all, you have been working, there is no dispute. You were working in the department. But during your working time, whether your post was regularized, it was not regularized. It was not regularized. So once your post is not regularized at all, then how can you get pension at this belated stage after 30 years? First, you should have approached the court or approached the department for regularize your job. Once your job is regularized, then only you will be eligible for pension. Without your job being regularized, how will you get pension after 30 years? After retirement, you retired when? When did you retire?
31/07/2011, Lordship. 31/07/2011, Lordship.
2011 you have retired, and after retirement of now 2026, after 15 years of retirement, you have come for pension. That too, your job was not regularized. How will you get the benefit?
Lordship, then I may be allowed to take you to page number 24, Lordship. Page 24, Lordship.
Yes, what is that, page 24?
The petitioner was released by common order, Lordship. The petitioner was released by a common order, Lordship. Release.
What released?
Release order, Lordship. Released from the service after completion of 35 years. The petitioner name is serial 5 P. Kim. The petitioner name is on 5 P. Kim. Serial number 5.
Serial number 5. Which order? You are saying page number?
24, Lordship. 24, page 24.
Annexer 2.
Yes, Lordship. Annexer to the petition.
Release order, yes. Have you challenged this?
No, Lordship. The petitioner was released by this common order, release order, Lordship.
Correct.
On completion of 35 years, Lordship.
Correct. Have you challenged this?
No, Lordship. We are placing this along with the judgment passed in page number 27, Lordship. Page number 27. Here, three employees were regularized and given the benefits, Lordship. The same name, one that is Sri Mongchen, page 27, the petitioner. And page 28, there is Sri Noksa, page 28. In page 29, Sri Puting Kiem. All these three names, it's even here in page number 24, there is common release order, Lordship. Mongchen, serial number 4. Puting, serial number 7. Noksa, serial number 8, Lordship.
See, this petition was filed for regularization.
Yes, Lordship, we are also filing
But,
for
but,
the...
but, the, but in your petition, whether you have filed any petition for regularization?
Yes, Lordship, yes.
When?
2025, Lordship.
You have filed a petition for pensionary benefits.
Yes, yes.
And that has been dismissed because your post was not regularized and you have approached this court without your job being regularized. But in this petition, there was a petition filed for regularization, and after looking into the matter, the court has passed an order regularizing their jobs. But in your petition, you have approached this court for pensionary benefits without being regularized, and you came after 15 years of your retirement. Those people have approached the court in 2015 only.
Lordship, we have filed this writ petition 218 of 2025, filed on 22/10/2025.
2025, so after how many years?
After almost 1 decade, Lordship.
Huh?
Almost a decade, 14 years.
Almost a decade. So how can you get the benefit?
Lordship, even the earlier order, it was only dismissed on the ground of delay in legislature.
It was dismissed on the ground of delay and laches because there was no explanation about delay and laches, and you cannot be. And another thing is that we have come for pensionary benefits. You see, in the earlier order, the writ petition under so and so for non-constitutional representative submitted by so and so for grant of scale of pay and regularization of service for pensionary benefits. So you have not approach this court in time. You will have to approach the court in time. You cannot sit down, sleep and then sleep around and then you come back after a long time. Those cases are not. Like your case.
Your Honor, even in the earlier writ petition, I've mentioned in page para 4, Lordship, that is the petitioner is an illiterate person and not aware of his legal rights.
The illiterate person is not he was a government employee. Now if you come and say he is an illiterate person, and do you think in law, simply being illiterate, you get some special benefits?
Lordship, he was not aware, the petitioner was not aware of
So what could be done? If he is not aware, what could be done? Law is not like that. If you are not aware, then what could be done after 15-20 years? Yes, government advocate.
Yes, Lordship. Since Lordship, the petitioner was in fixed Lordship, and the OM also it doesn't cover Lordship since he was in fixed pay Lordship.
Yes.
So Lordship, and with regards to the other petitioners Lordship, they have approached the court after 2 years and 4 years Lordship. And in this case, in this present writ petition Lordship, the petitioner has approached the court after 14 years Lordship. And during his service Lordship, he has never submitted a representation Lordship. Only in the year 2025 Lordship, he submitted a representation Lordship. So his case cannot be considered Lordship.
Your Lordship, regarding delay, may kindly come the para for Your Lordship. Para 4, page number 6 of review petition, Lordship.
What is there?
We have placed the Supreme Court citation judgment, Your Lordship.
Supreme Court says what? You read.
Paragraph 4, Lordship, page number 6.
You read what Supreme Court says.
Paragraph 6, we noticed that the appellant was working as a gangman who died while in service. It is on record that the appellant is an illiterate who at the time did not know of her legal right and had no access to any information as to her right to family pension and to enforce such right. On the death of the husband of the appellant, it was obligatory for her husband, employer, which the railways.
So he was a regular employee. He died. So his wife was not aware of any pension or any pensionary rights. That is why Supreme Court has stated that he already has the right to get pension since he has worked. But you worked in a fixed pay scale, fixed pay basis. So you don't have any pensionary right. There is no right accrued to you. In this case, in the Supreme Court, that person has already worked there on a regular basis. So he has the accrued right of pension. That cannot be denied. So that's why the Supreme Court has allowed that. But in your case, you worked in a fixed pay basis. You retired. Before retirement, you did not take any steps for regularization of your job. You retired as a fixed pay employee only. Then after retirement, after 15 years, you have come to the court, approached the court, saying that you should be given pensionary benefit. After retirement, your job should be job should be regularized and to be given pensionary benefit. How it can be given after 15 years?
Lordship, like mentioned, he was not aware of his legal rights.
So I am saying you that like the not being aware is not an excuse.
But then, Lordship, in similar matter,
those are not similar matters. They have approached the court in right time and their jobs have been regularized by the court.
I agree.
But in your case, we have not approached the court in right time. You have come after 15 years of our retirement. Tell me what is to be done. I will dismiss it, or you want to withdraw it, otherwise I will dismiss it. There is no ground of any review.
Then my humble prayer, your Lordship, my senior may conduct this case.
No, he cannot go on like this. We have given already one time, we have already given. We have allowed you time once. It was listed earlier also. Earlier also I have given you time, saying that you come prepared. If you have anything something in your favor, you bring on record and place before this court. But he could not do it. It cannot go on like this.
Lordship, my humble prayer, Lordship, last chance maybe.
No. Last chance cannot go on just like this. You cannot take judicial time like that. We have given you time earlier also. You tell me what is to be done. If your senior is so serious, then your senior should have been there in the case today. Why he is not there?
No, your Lordship, that's my. I will take on the blame, Lordship.
What?
He was about to take this case. I insisted my senior to take up the case by myself.
Then it cannot go on like this. I am dismissing this. Or you want to withdraw, you say we want to withdraw, or otherwise I am dismissing this. There is no ground, Mr. Counsel. There is no ground at all. There is no point spending time on this. How this review can be filed? What is wrong? What is wrong in the order? Yes, tell me.
Then, Lordship, I may be allowed to withdraw, your Lordship.
Your name? Yes, please address the court.
Then, Lordship, it may be dismissed, Lordship.
You want to withdraw, or we want you to dismiss on merit?
Dismiss, Lordship.
Then we will pass the order.
Yes.
Heard, what's your name?
W. Yakab Konyak.
Just pronounce your name properly.
W. Yakab Konyak.
Okay, T. Konyak, the learned counsel appearing for the petitioner, also heard. Madam, your name, please.
Chang, Lordship. S. Chang.
S.
Chang.
S. Chang, the learned government advocate.
Yes, Lordship.
Learned government advocate for the state. Hearing concluded, judgment reserved. I'll pass.
Much
the order.
obliged.
Much obliged.
Hearing item 4.
Yes.
Lord, if I may continue from page 26 of the paper book, my lord.
Page
26.
26.
This is the evidence of PW number 4, case IO.
Yes.
I know the accused persons. They are the person from whose possession the essay were seized. On 23/20/21 at 4:30 p.m., SIEN, AFL Nunklong Anti-Narcotics Squad and party performed duty at Ral Bomram, Bukpui area, and they had arrested 1. Zarzawa 45, son of so-and-so, 2. Lalduoma 25 years, son of so-and-so, in connection with the seizure mentioned in column 3 of this sheet. The said accused persons were sent to the district hospital, Kolosip, for medical examination, and the examination report showed that they were medically fit to be kept in the custody. He also submitted a report of seizure and arrest to the OC, Excise and Narcotics Station, Kolosip, and case number so-and-so dated 21/3/2020. Under Section 21C of NDNPS Act was registered against the said accused person, and I was endorsed the case for further investigation. During the course of my investigation, I examined accused persons, seizing officer, and the witnesses. I also recorded their statements under good atmosphere. I also sent sample of the seized article at FSL, and the result shows that the purity of the seized heroin were 77% at the time of examination. I also visited the PO along with seized witnesses. My investigation reveals that the seized articles were recovered from the possession of the two accused persons while they tried to hand over the seized articles to another person. The two accused were brought the said articles from Mauchar, and they were arrested at the roadside of Serkantu Bagaro, 8 kilometers away from Bupui. They stated that this is the Mizo vernacular
Yes.
again. Hence, I found a prima facie case well established against the said accused person under 21C of NDPS Act 1985, and I charged them accordingly for violation of Section 8C of NDNPS Act 1985. And these are the exhibited and the cross-examination portion number 1. It is not the fact that the essay were seized from inside vehicle. Here, my lord, what I'd like to mention is that the PW3 stated that it was recovered from inside vehicle. Earlier, that is the statement made by the PW3, who is also the sub-inspector of excise and narcotics. In his cross-examination point number 2. But here he stated that the PW4 stated that at number 1, it is not a fact that the essay were seized, not a fact that the essay were seized from inside vehicle. Number 2, it is a fact that seizing officer is not from the Office of Excise and Narcotic Department, Kolosip. Number 3, it is not a fact that the accused Lalzarzo was sitting inside the vehicle when he was arrested, meaning that the accused was not sitting inside the vehicle. Number 4, it is a fact that both the accused while arrested were holding the seized articles. He stated that they were holding the seized articles, but the PW3 had stated that it was not recovered from the physical possession of the accused. Number 5, it is a fact that another person other than the accused persons was present at the PO. Number 6, it is a fact that one private car was there at the PO which was not owned by the two accused. It is a fact that the said one person who was present at the PO was not arrested. It is also a fact that the said vehicle was not seized by the excise personnel. Number 8, it is a fact that the accused Omar did not plead his guilt before me and also on his statement which I recorded under the excise custody. Number 9, it is not a fact that there was one person other than the two accused which is civilian at the PO and he was not arrested. 10, it is a fact that the said one civilian person used to indulge in this type of offense. It is a fact that the above said person was not included on the witness list. It is a fact that I do not have the documentary proof that the said vehicle and the person sitting inside the car was a decoy customer and a decoy vehicle. Re-examination part. In respect of paragraph 5 of the cross-examination, the person present at the PO other than the accused persons was our decoy. In respect of para 6 of the cross-examination, the private car at the PO, which was not owned by the accused persons, was hired by our department. Here, my lord, from the evidence of the PW number 4, what can be seen is that from his statement, he stated that the essay was recovered while the accused person were holding the articles. But the PW3 had stated that it was not recovered from the physical possession. There was a contradiction in that regard. And my lord, here it was also stated that the PW4 had stated that it was not recovered from the vehicle, inside vehicle, but the PW3 had stated that it was recovered from the vehicle. In that regard, there was also a contradiction, my lord. And if I may go to the evidence of the PW5, this is the last witness for the prosecution, my lord, at page 29. This is Srilal Monuma. He is an FSL expert. On 25/3/2021, we received samples of suspected heroin packed in 26 polythene packets in connection with case so-and-so dated 21/3/2021. The samples were packed and sealed and enclosed in a paper envelope sealed with wax seal. I, along with Dr. R. Lomzoli, conducted examination of the said samples, and the said results show that the samples contain heroin with a purity of about 77% at the time of the examination. On cross-examination, it is a fact that I do not know whether or not the essay was owned by the accused.
Yeah, this is not important. This is not important. This is only for the purpose of whether it's a heroin or not.
Correct.
Then come to further deposition. Whose deposition is this? This is page 30.
Page 30 is the deposition of the defendant, the defense witness.
Defense witness. Who is this?
Witness. This is Mary John. Is the she said like this.
She is the wife of one of the accused.
Correct. I am the wife of the accused Arzawa, and we permanently resides at Mauchar. My friend, owner of the essay, Rolupui, is my childhood friend and came to Mauchar for business, and that she begs us to deliver her goods to NIPCO, and with good deeds and without knowing the content of the package, my husband Zarzawan Lalduoma with his bike went to deliver the said package to the location that Rolupui gave us. But later I came to know that they were arrested by excise personnel. We do not know what is inside the package, and it was perfectly packed, and that she gave all the cost for hiring the bike. On cross-examination, it is a fact that on 23/2021, my husband accused Arzawa had actually hired the bike owned by Lalduoma. Lalduoma is the co-accused. Number 2, it is a fact that Rolupui had sent my husband to deliver the goods, and she also promised my husband to give money. It is a fact that the goods package had never been opened by my husband. And my lord, at page 31 is the evidence of DW number 2. H.K. Lalkuma, 70 years. The accused Lalduoma is my nephew, and I took care of him since childhood. We mostly stayed in Kolosip. He played football since childhood and used to play under academy, and even played for Mizoram in Sobrato Cup under 14 tournament, and he was even hired by the Air Force Football Club, Delhi. But he could not stay in Delhi for long and came back home due to the fact that as he stopped playing football outside Mizoram, and as there is financial issues at our home, I asked him to go to Mauchar with his bike and make his bike for rental, as there are no vehicle service in Mauchar. Even on the day of the alleged incident, he was hired by Zarzawa, and he does not have any knowledge about the seized article. Moreover, he doesn't have any involvement in this alleged incident. He stated mouth charges to earn money from rental as we have faced financial issues at home. Cross-examination 1. It is a fact that I was present on the day of the incident, and as such, I do not know whether any contraband articles had been seized from the possession of Lalduoma and Zarzawa Adral Bomram, Bukpui area. Number 2. It is a fact that accused Lalduoma never indulged in taking illicit drugs. It is a fact that I do not know whether accused Lalduoma had knowingly let the co-accused hired his bike or not. This is the last witness, my lord. Here, by passing the impugn order, the accused Zarzawa was convicted and the co-accused was acquitted, my lord.
Who is convicted?
Zarzawa,
Hmm.
the present appellant, my lord.
Okay, and then co-accused, the footballer was acquitted.
Yes, my lord, acquitted.
Hmm.
And if I may go to my lord, the observation made by the trial court.
Hmm. So what is your case basically? What is your point? What is your strong point?
Basically, my lord, I'd like to press. What I'd like to mention is that those contradictions made by the PW3 and PW4, who are the sub-inspector, both the sub-inspectors of the excise and narcotics, my lord.
Is it a case of implant?
It might not be, my lord.
Then how come? Then where from this narcotics appeared?
That initially it was appeared from the report made by the Assam Rifles. Report was received on 19.
So there was a secret information that there may be some drug trafficking, correct?
Yes.
And on the basis of that, a report was made, and then they trapped these two people, these two persons. Yes, there are some contradictions or here and there, diversions regarding the statements. From where exactly this was, from the vehicle, but because they are saying there was one other vehicle was there.
Yes.
Then that vehicle is basically hired by the police officers, excise officials.
My lord.
Then from the bike, it seems that though they didn't mention about bike earlier, I think they are meaning bike only.
Yes.
Correct?
Yes.
They were traveling by bike only, not by
Bike only.
by
Yes.
four-wheeler. As they have mentioned vehicle, but it is basically a bike. So from the bike, there are things that it was supposed to be handing over to some other person. At that point of time, they catch hold of the person, and they have put a decoy buyer also, decoy customer.
Yes, my lord.
So what is your case? What is your, defense? Where are those infirmities?
The infirmities was that, my lord, here those contradictions are there, but when the defense statement was given, it was again stated that they do not have the knowledge about the contents of those disease article. Without knowing the contents, they are requested. The main accused is requested by one person by the name of Rohlupui to.
Have you brought him? Have you brought that person to the court?
No, my lord.
Then-
That particular person, there was no steps taken on the part of the prosecution to.
Then from the defense side also, you haven't brought him.
There was no step taken.
There was no
from the
step taken. There could have been cross-examination from the defense.
That it seems that there was no steps taken
Now
from
see,
perusal of the record.
there is a packet of certain material. Now what is there inside or not inside? whether you have the knowledge or not, how you are going to prove that? So it can be done, it can be negated only by cross-examination. Maybe cross-examining that other person who has delivered
Yes.
those materials. But that person hasn't been brought as a defense witness, or, but I don't think he will come as a defense witness.
Yes, that may be
That
difficult.
definitely will not come. But he could have been called for cross-examination purpose.
Anyway, my lord, here,
Yes.
that those things were not done, and it had attained finality already, and the defense with stage of those defense evidence was already closed, and
No, whatever he has done. Now
Yes, yes.
you have some case laws.
I would like to rely with the Katsing, the Katsing judgment, Union of India.
Yeah. Yes, Katsing, which
did this
paragraph?
in para 16, my lord. Para 16.
Yes.
If I may read, my lord. Law on the point is very clear that even if there is any sort of procedural illegality in conducting the search and seizure, the evidence collected thereby will not become inadmissible, and the court will consider all the circumstances and find out whether any serious prejudice had been caused to the accused. If the search and seizure was in complete defiance of the law and procedure, and there was any possibility of the evidence collected likely to have been tampered with or interpolated during the course of such search and seizure, then it could be said that the evidence is not liable to be admissible in evidence.
So in your case, there is, I mean, as far as search and seizure, you don't have any issues. You have not
Yes.
raised any issue.
Yes, the main issue pertains only to with regard to the contradiction, my lord, the contradiction of the
Yeah, correct.
PW3 and the
But
PW4.
as far as search and seizure, you don't have anything. You have not raised any issue while in your defense
Yes,
about
that is-
search and seizure.
That is correct.
Correct. So this case will not be helpful to you, because here it says about the search and seizure. If there is some defects in search and seizure,
Yes.
then also, I mean, if there are some procedural lapses, then also court needs to consider the whole circumstance, and on the basis of that, court should go on. But in your case, nothing has happened. As far as search and seizure, you don't have any issues. And what about the other case, Nouraga?
This Nouraga is with
Nouraga
regard to
is a famous case, yes.
Yes, my lord. That
Para?
the para number is not given, but that in the second, I have the printed copies copy of only the relevant portion, my lord.
Only relevant portion.
At page 18, at the middle paragraph, my lord.
This way it is difficult. You should always give the whole case.
I can provide also, but it's around page 36, like.
But yeah, but you'll have to give. If it is runs
Yeah,
36 or
I'll
36,
surely give, my lord.
You'll have to give.
Yes.
But this way, because I mean, these cases are NDPS cases are very tricky. Factual things,
exactly,
the
ma'am.
procedural
Exactly.
things. I mean, all the cases are, you'll find little bit different here and there. And
Ma'am.
from those differences, it can be distinguished. then it becomes, if you cannot read the whole case,
My lord.
then it becomes difficult.
Exactly.
Only reading one paragraph, it becomes very difficult to rely on. I mean, what exactly happened? Because all the cases, facts are different.
Exactly, my lord.
And whether the procedure has been followed or not, it's becoming. But which paragraph here, which,
At the middle portion of page, the second page.
that 34 and 35 and
Yes,
54?
yes, that paragraph.
Hmm.
Section 35 and 54 of the Act, no doubt, raise presumption with regard to the culpable mental state on the part of the accused, as also place burden of proof in this behalf on the accused, but a bare perusal the said provision would clearly show that presumption would operate in the trial of the accused only in the event the circumstances contained therein are fully satisfied. An initial burden exists upon the prosecution, and only when it stands satisfied, the legal burden would shift. Even then, the standard of proof required for the accused to prove his innocence is not as high as that of the prosecution, whereas the standard of proof required to prove the guilt of the accused on the prosecution is beyond all reasonable doubt. But it is preponderance of probability on the accused. If the prosecution fails to prove the foundational facts so as to attract the rigors of Section 35 of the Act, the actus reus, which is possession of contraband by the accused, cannot be said to have been established. So here, my lord, I will provide the full text, my lord.
Yes.
By relying on this judgment, what I'd like to submit is that, my lord, the standard of proof required is on the part of the prosecution is
very high.
Yes, very high. Because in a special act like this, the punishment is also severe. So there has to be a fully corroborated case on the part of the prosecution, my lord. That is what I'd like to submit before your lordship, my lord.
So, what about the 313 statements? Is there any 313 statement?
313 statements is available, my lord, here. 313 is at page 4. Page 4 and 5 of the paper book.
4 and 5?
Yes.
And where is that order of acquittal? The same order only is acquitted?
Yes, in the same order only. In the same impugn order. So, my lord, here, if I may go to the decision, the observation made by the trial court, which is at page 37, with regard to the possession of the contraband. If I may read from page 37 to till 39, my lord. PW3, namely, Mr. F. Lordship has it, my lord?
Yes.
Mr. Evelyn Ntluonga, SI of Excise and Narcotics Department, deposed that he received the secret information on 9/3/2021 from 46 Assam Rifles about trafficking of large quantities of contraband substances within Kolosip area. In pursuant to this, he put the said information in writing first, formed a team, and then pursued the case. The next day, that is 23/2021 at 4:30 p.m., he seized 24 grams of yellowish powder suspected to be heroin kept inside 26 soap cases, which was wrapped in white polythene and backpack from the possession of the two accused persons in presence of two civilian witnesses at Buk Puiral Bomram. He arrested the two accused persons. Exhibit P2 is a copy of seizure and arrest memo, and Exhibit P2A is his signature. On cross-examination, he stated that the seized substances were not seized from physical possession of the accused, but seized from inside a vehicle, Renault Kwid, but not recall the color. He added that the accused number 2 Duma was not sitting inside the vehicle while seizing the contraband substances from inside the vehicle. On careful perusal of evidence produced by PW3, it is noticed that he did not clearly mention where the accused Zarzawa was there, while he clearly mentioned that accused number 12 Duoma was not there inside the vehicle. PW1, namely C. Vanal Moya, resident of Buk Pui, deposed that on 23/20/21 at 4:30 p.m., excise personnel seized 324 grams of yellowish powder suspected to be heroin kept in 26 soap cases from the possession of the two accused persons. Zarza was son of so-and-so and Dalduom was son of so-and-so at Buk Pui Ramral Bomram. He added that he was present when the seizure and arrest were made, and as such he stood as seizure witness. Exhibit P2A is his signature. On cross-examination, he stated that he did not know if the seized substances belonged to the accused or not. He denied the suggestion that he was not on the side of the excise personnel. PW number 2, namely Mr. H. Celsium, a resident of Buk Wiveng Sang, deposed that on 23/20/21 at 4:30 p.m., excise personnel seized 324 grams of yellowish powder suspected to be heroin kept in 26 soap cases from the possession of Zarzawa, son of so-and-so, and Dalduoma, son of so-and-so at Buk Puiral Bomram. The accused were also arrested, and he was present when the seizure and arrest were made, and as such, he stood as seizure witness. Exhibit so-and-so is his signature. On cross-examination, PW2 stated that he did not know if the seized article belonged to the accused or not. He denied the suggestion that he was not on the side of the excise personnel. PW4, namely Mr. Elbi Luna, deposed that during the course of his investigation, he collected evidences revealing that the excise and narcotics team under the command of Evelyn Tlunga, SI of ENN, seized contraband substances from the possession of the two accused, and consequently the two accused persons were arrested. PW4 clearly stated that seizure of contraband substances and an arrest of accused was made while the excise team performed duty at Ral Bomram, Buk Pui area. He stated in para number 4 of his cross-examination that both the accused while arrested were holding the seized articles. On careful perusal of the evidences produced by the prosecution, particularly PW3 and PW4, this court noticed contradicting statements. While PW3, that is seizing officer, stated in para number 1 of the cross-examination that the contraband substances were not seized from the physical possession of the accused, and also stated that he seized the contraband substances from inside a motor vehicle, Renault Kwid. He also stated in para number 4 of his cross-examination that one person other than the accused Zarzawa was sitting inside the vehicle from where the said articles were recovered, and the said person was not arrested, and the said vehicle was not seized as well. Meanwhile, PW number 4 stated that the two accused were holding the contraband substances while they were being arrested. Seizure witnesses PW1 and PW number 2 stated that the contraband substances were seized from the possession of the two accused. Defense witness, namely Mrs. Mary John, wife of accused Zarzawa, stated that while her husband and accused Duoma rode on a bike belonging to the latter to deliver goods to Nipco, belonging to her friend Rolupui, they were arrested by excise personnel through claimed oblivious unconscious of the contents of the bag. But as per evidence of the seizing officer PW3, the substances were recovered, seized from inside one vehicle, Renault Kwid, inside which one person other than accused Zarzawa was sitting. Here this court noticed contradictions of evidences adduced by PW1, PW2, and PW3, who were the very persons present together at the same time and same place and making seizure of the contraband substances. Though there are contradictions in the evidences of seizing officer and his witnesses, one thing that is clearly revealed is that contraband substances were seized on the occasion complained of. Another one thing that came to light is that the contraband substances were seized from inside the vehicle, which was being occupied by one person whose name was not mentioned in all the evidences produced by PW1, PW2, PW3, and even the case IO PW number 4. One more thing that came to light is that nothing was seized, recovered from the possession of accused number 2, namely Lalduoma. This court finds it safe to conclude that the excise and narcotics officer seized the contraband substances from the accused number 1, namely Zarzawa, while nothing was recovered from the possession of accused Lalduoma. My lord, here the observation given by the trial court is that it says like it finds it safe to conclude, but it can be seen that the contraband was recovered from inside the vehicle.
No, that's there is a statement that 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 whatever is there in the bag was carried by him. He admitted that. Only thing is that what is there inside he was not aware. So indirectly he has admitted that contraband was with him.
Yes.
Correct.
Correct.
So
This is
only
part-
thing is that his statement is that he was not aware what is inside. The initial statement. Anyways, we'll see what is to be done.
My lord.
Anything more else?
My lord, yeah, I
You covered all probably.
yeah, I covered the whole portion.
Yes, madam.
Yeah, please, Your Lordship. From what my learned friend, the senior counsel, has read out, my lord, it can be seen from the paper book that the appellant was caught red-handed while trying to hand over the seized article to one person who was a decoy customer of the excise and narcotics. And therefore, my lord, possession of the appellant is proved. Moreover, my lord, he has admitted in his 313 statement that he was carrying the bag to NIPCO to deliver it to someone else. And not only that, my lord, the co-accused in the case, who was acquitted, later acquitted, my lord, even in his 313 statement, he has admitted that the appellant has hired him to go to NIPCO and he was, deliver some,
So he is in the business of hiring of the vehicles.
yes.
I mean, giving on rent or whatever.
Yes, my lord. Number two
Just
is a
like
driver.
Rapido
Yes, my lord.
vehicles.
Yes, he has a bike which is used for rent. So he has a bike, motorcycle, which was rented
Which
out
is hired by
sometimes.
people.
Yes. So yes, my lord. So at this time he has admitted that it was rented out to the appellant, so that they can deliver the bag to someone else at NIPCO. So, my lord, the possession is very clear from all the statement of the prosecution witnesses. The only contradiction which he talks about is that it was found in the car or elsewhere, not in the physical possession. But, my lord, this should not...
This Renault Kwid was hired by whom?
By the excise. It
By
was
excise department.
Yes, it was a decoy customer. Since they have received the report, they have made a decoy customer so that they can catch the appellant. So, my lord,
But the prosecution has not brought this decoy customer to the court.
No, my lord.
Why?
They are mostly not mentioned also.
Usually they do not disclose the names.
They don't disclose the names. And, my lord, like we have stated, there is no procedural lapses in this case. All the procedure has been followed.
Now they have not taken any ground also as far as procedural lapses are concerned.
Yes, my lord, no grounds. So, my lord, what I'd like to say is that prosecution witness statements are all corroborated by the 313, the statement also. And moreover, the FSL report, it turns out positive to be heroin. So there is a good chance of him being convicted. And the learned trial court has rightly convicted him. So, my lord, the order, the judgment and order may be upheld. That is my prayer. And I have a citation. I don't know whether it will be necessary because it's a very common one, my lord.
Which
that
one?
Once possession is established, it is the duty of the possessor to prove that it was not in his knowledge.
Now give me the citation.
Yes, my lord, I'll give it. This is at para 16.
Dharampal Singh.
Dharampal Singh. And my lord, they have taken one defense that they have named a person, Rohlupuyi, who was the owner of the bank. But my lord, this appears to be a belated thought because it was never mentioned during the investigation. Only at the time of prosecution witness and the 313 statement, defense evidence and 313, they have mentioned that someone named Rohlupuyi is the owner of the bank. So it's like a belated.
It was not there before.
No, my lord. From the charge sheet also, it's not there. That is why investigation also, it was not carried out.
Okay, we'll reserve the judgment and pass the judgment.
All right.
Judgment reserved. Heard Mr. F. Lalgiana.
Lalengliana.
I'm extremely sorry for my pronunciation. It will take little bit of time. So how do you pronounce
Lalengliana.
Lalengiana?
Malo.
Lalengiana. Lalengliana. Lalengliana, learned senior counsel, assisted by Mr. So, learned counsel as amicus curiae.
Malo.
As amicus curiae. Also heard Ms. Linda M. Fembuel, the learned public prosecutor for the state respondent. Hearing concluded, judgment reserved.